shall give their attention, for the court is now in session.
The clerk of code for today's continuation of oral arguments are the cases in GR number 245, Bayan Muna Representatives Neri Javier Carlos Zarate et al. Versus Energy Regulatory Commission et al. GR number 210255, National Association of Electricity Consumers for Reforms, represented by Petronilo L. Ilagan et al. Versus Manila Electric Company et al. And GR number 210502, Manila Electric Company versus Philippine Electricity Market Corporation et al. Appearing as amicus curiae are Professor Roaldo Del Mundo and Dr. Maria Joy V. Abrenica. Appearing as counsels for petitioners in GR number 210245 are the following: Attorney Carlos Isagani Zarate, Attorney Maria Cristina P. Yambot. Collaborating counsel for petitioners in GR number 210245, Attorney Edre Olalia. Appearing as counsel for petitioners in GR number 210255 are the following: Attorney Leonard S. De Vera and Attorney Ronnie Rodillas. Appearing for the public respondents are the following: Assistant Solicitor General Vida G. San Vicente, Senior State Solicitor Elma Rafalio Elingan, Senior State Solicitor Telma Lee Raquel Sadoy, State Solicitor Marie Christine Nolasco Jimenez, Associate Solicitor Dexter Matias, and Associate Solicitor Ivan Bandal. For the Department of Energy, we have Secretary Carlos Jericho Petilla. For the Energy Regulatory Commission, we have Chairperson Sinaida Cruz Ducut, Attorney Francis Saturnino Juan, Attorney Deborah Anastasia Layugan, Attorney Grace V. Lu Santos, Commissioner Alfredo Non, Commissioner Gloria Victoria Yap Taruk, Commissioner Josefina Asirit. Appearing as counsels for private respondents, Manila Electric Company, are the following: Honorable Florentino P. Feliciano, Attorney Victor P. Lasatin, Attorney Carlos Roberto Lopez, Attorney Anthony D., Attorney Arnold Corporal, Attorney Antonio Eduardo S. Natura Jr., Attorney Filimon Ray Javier, Attorney Clarissa Bettina Failona, Attorney Monica Joy M. Marcelo, Attorney Jermaine Chua, Attorney Hazel Rose C., and Attorney Francis Paulo Pianco. For the Philippine Electricity Market Corporation, Attorney Criselda Martin Funelas, Attorney Celina Encarnacion, Attorney Gladys Yvette Nebab, Attorney Maria Lourdes Sabundayo. For SEM Calaca Power Corporation, Attorney Gwen Grecia de Vera, Attorney Nadia Katrina Estrella, Attorney Rowena Fatima Salonga, Attorney Rafael A. Evangelista. For Masinloc Power Partners Company Limited, we have Attorney Ruben Gerard Recasata III, Attorney Zan Paulo Pacificador, and Attorney Irvin Joseph Fabella. For Therma Luzon Incorporated and Therma Mobile Incorporated, Attorney Roderico V. Puno, Attorney Helena Rosales Calo, Attorney Richie Abigail Ramos Pilares, Attorney Christy Aurel Enriquez. For San Miguel Energy Corporation, South Premier Power Corporation, and Strategic Power Development Corporation, Attorney Alexander Poblador, Attorney Nick Emmanuel Villaluz, Attorney Ansen D., and Attorney Estrada. For First Gas Power Corporation, FGB Corporation, Bachman Energy Development Corporation, Bachman Geothermal Incorporated, and First Gen Hydropower Corporation, we have Attorney Mario Luza Bautista, Attorney Joseph Jomer Perez. For Quezon Power Philippines Limited Company, we have Attorney Mona Lisa de Malanta, Attorney Joshua Gilbert Paraiso, Attorney Jessica Christine Helado, Attorney Maria Teresa Vivian Ventura Pugeda. For National Grid Corporation of the Philippines, Attorney Mark Anthony Actub, Attorney Rachel Baldovino, Attorney Ronald Dailan P. Concepcion. For 1590 Energy Corporation and Vivant Santa Clara Northern Renewables Generation Corporation, Attorney Regan de Guzman, Attorney Jess Anthony Garcia, Attorney Joan Geducio Baron, Attorney Marvy Humaod Arnoco. And for AP Renewables Incorporated, Attorney Cesar E. Santamaria. For Pan Asia Energy Holdings Incorporated, we have Attorney Emmanuel P.J. Tamase, Attorney Glenda Isabel Biason. For Power Sector Assets and Liabilities Management Corporation, Office of the Government Corporate Counsel, Attorney Raul Criencia, Attorney Melissa M. Acorda. In-house Counsel, Attorney Federico Quevedo, Attorney Cecilio Heliada, Attorney Marnie Benjamin Mamaril, Attorney Geoffrey Delara Masankay, and Attorney Abdul Halim Diron. For SN Aboitiz Power, Attorney Anthony Mark Gutierrez. For TransAsia Power Corporation, Generation Corporation, Attorney Alan Ascalon. And the Council for Intervenor Private Electric Power Operators Association, Attorney Ranulfo M. Ocampo. To argue this afternoon will be Respondent Meralco through Attorney Victor P. Lasatin, who shall have 30 minutes to discuss issues A, B, C, D, E, G, and H. And Honorable Florentino P. Feliciano, who shall have 10 minutes to discuss issue F. Then we will proceed as the Chief Justice shall direct.
Thank you very much, councils. Please take your seats while Counsel for Respondent Meralco will please prepare to take the podium. Allow me to inform the Counsel for Meralco that the court has denied your request for an additional 10 minutes for the presentation. In any case, there will be the oral arguments at which there is always the possibility for you to interject those additional points you had wanted to make for your presentation. So we will now have Attorney Lazatin, please, for your 30-minute presentation of your arguments.
With the permission of this honorable court, good afternoon, Your Honors. In this matter, Your Honors, the petitioners representing the consumers are questioning the increased pass-through generation charges of the generation companies, or GenCos, brought about by the overlapping shutdown of the Malampaya facility as well as several GenCos. Petitioners take no issue with the distribution charge of Meralco, which have not changed. And yet, we find ourselves in the vortex of this controversy, which should have been a case between the consumers and the GenCos on one hand. It should have been an interpleader case, Your Honor. At the outset, we'd like to stress Meralco is merely a distribution utility, and its share of the electric bill is only the distribution charge. Meralco is not responsible and has no control for the shutdown of the generation plants. The distribution charge during the period of November, December, and up to now have not increased and have remained the same. Meralco will absolutely not gain nor benefit, not a single centavo, from the collection of these pass-through charges. Meralco proactively took remedial and mitigating measures to, among others, secure additional supply to cover the shortfall due to the scheduled Malampaya shutdown. Meralco sought the guidance of the ERC to mitigate by staggering the collection of those pass-through charges which it could have collected at once in one billing month. Even with the aberrant December and January spike in the average generation charge, the annual for 2013 is still lower than the average annual generation charge for 2012. Lastly, Meralco was enjoined from collecting these pass-through charges from its customers, and yet the GenCos and the other beneficiaries of these pass-through charges were not similarly enjoined from collecting from Meralco. To have a better understanding of the issues and the electric power industry, we thought it best, Your Honors, to present a few slides pertaining to the supply chain. First in the supply chain are the generators. Second, the transmission through high voltage wires. Third is the distribution of the electricity through low voltage wires. And fourth, the supply sector, which is a new sector that will develop with the retail competition and open access. And all of this to serve the end users or the customers. The legal structure of the electric power industry is determined and mandated by Congress. The pre-EPIRA structure note that the generation and transmission sectors were a monopoly of the state through the NPC, while the distribution was competitive. Under EPIRA, the industry was divided into 4 sectors. Transmission and distribution were declared to be public utilities as they are natural monopolies. It does not make any sense to allow 2 sets of wires or 2 sets of poles on the same street when one will do. ERC regulate the rates for transmission and distribution. On the other hand, Congress determined that generation and the supply side were competitive. They are not public utilities. They are not required to secure a national franchise. They are, however, subject to, among others, the rules on market abuse as well as anti-competitive behavior. Part of the EPIRA is the unbundling of rates. For transparency, the retail rate was unbundled into its different components. But an unstated sector in the power industry is fuel. It is important because the fuel costs constitute approximately 60% of the cost of the GenCos. The prices of fuel such as coal, oil, fluctuate with the world market prices as well as foreign currency fluctuation. Interruption of the fuel supply, such as that of the Malampaya shutdown, affects significantly the supply of power or the supply chain. Please note that Meralco is not allowed to profit from these pass-through charges. Meralco only keeps the distribution charge. The opportunity to be heard and due course is observed for each of the component of the Meralco bill. Of particular importance, Your Honor, is the generation charge. Before the charging, the power supply agreements, the automatic adjustment mechanisms, the WESM price determination, and other rules were all approved by the ERC after due notice, publication, and hearing. After charging, the same will be verified and confirmed, again, after due notice, publication, and hearing by the ERC. Note that the generation charge, as I mentioned, is 60% of the fuel cost. Transmission is now under the concessionaire, the National Grid Corporation of the Philippines. Part of the retail charge would be the systems loss, the cross subsidies, taxes, local franchise, the value-added tax, and the energy tax. Missionary electrification and the environmental charge, stranded costs of the NPC and also for its contracts is the so-called universal charge. Meralco's distribution charge for distributing and metering electricity are regulated under Section 43F of the EPIRA Law. Note that the distribution charge is only 7% of the retail rate. Generation charge is approximately 57%, and approximately 60% of this is for fuel costs. Your Honor, we will skip with our presentation with respect to the regional comparison of electricity prices, and we will revert to it if time will permit. Allow us now to go into the supply and demand of electricity. Electricity cannot be stored or impounded in mass. It is a highly perishable article. If you do not use it, you immediately lose it. Demand for and supply of electricity are volatile and dynamic, but supply must meet demand instantaneously. Demand cannot be predicted with certainty and at best can only be estimated based on historical records, anticipated weather, and market events. Demand for power varies within the year, within the month, within the week, and within the day. Supply must be geared to meet the peak demand, and the peak months are the coming months of March, April, May, and June. The quantity injected or supply must clearly match the quantity withdrawn, the demand, moment by moment, within a very narrow band of tolerance. Meralco is not a power generator. It sources its supply to meet the forecasted demand as follows. Over 90% is through bilateral agreements, the so-called purchase supply agreements or the power purchase agreements. And up to 10% is sourced through the WESM to cover any shortfall. Your Honor, this is the profile of the Meralco's supply contracts. Natural gas, coal, oil-fired, and renewable energy, amounting to over 5,000 megawatts. These contracts were subjected to ERC approval after notice, publication, and hearing. Please note that the intervenor, Nasecore et al., intervened in 2 of these proceedings. For the first 5 years of the operation of the WESM, that is from 2006 to 2011, Meralco was required to source at least 10% of its total demand for power from the WESM. Meralco continues to short from the WESM for any of its shortfall that is not supplied by its bilateral contract. Due to the scheduled Malampaya shutdown, which supplies natural gas to 3 plants, approximately with a capacity of 2,700 megawatt. This is approximately 54% of Meralco's bilateral contracts. Thus, this 2,700 megawatts of power will not be available. To fill the gap, gas-fired plants had to run using alternative fuel, which is more expensive. Meralco was proactive in seeking and undertaking mitigating measures to cushion the impact of the scheduled Malampaya shutdown. It agreed with Ilian Block 1 to have it run to 420 megawatts using biodiesel. With pure diesel, Ilian Block 1 could have supplied 600 megawatts, but it was mandated to use biodiesel. Meralco agreed to run the Santa Rita plant for 100 megawatts using condensate, a light liquid fuel. Meralco also signed a power supply agreement with Thermomobile, or TMO, for 100 megawatts and up to 234 megawatts for this year, and that is for its peak requirements. Meralco also requested 2 plants who had scheduled shutdowns that were going to overlap with Malampaya to delay their scheduled shutdowns. It was successful in convincing one. During the conference between the different stakeholders, Meralco recommended to use WESM-administered prices during the Malampaya shutdown, and it also actively participated in these coordination meetings. Notwithstanding Meralco's efforts, Meralco had to source more power from WESM, which is geared to clear at the highest marginal price. Because of the extended shutdowns, the forced shutdowns during the months of November and December, as shown in this slide. The share of WESM to fill the gap increased from 11.56% in November to 14.08% in December. Note, Your Honors, that the gas-powered plants effectively became oil-fired plants, and the fuel, Your Honor, is more expensive. Coal is less expensive compared to gas, and bunker fuel or diesel fuel is the most expensive of the fuels. Thus, for the December billing month or November supply month, the generation charge increased by 3.44 pesos per kilowatt hour, broken down into 1 peso, 0.3 pesos for natural gas, because it used the more expensive fuel replacement. That is the cost. And 2 pesos, 0.42 for the WESM purchases. That is, with the increase in generation charge of 3.44 pesos, it had a ripple effect on the taxes and also on the others. This is the universal charge as well as the other subsidies, Your Honor, thus bumping up the increase to a total of 4.15 pesos for that month. Note that there was no increase in the distribution charge of Meralco. Meralco's proposal to stagger the increase was to cushion the rate so that its impact to the customers will be lessened, and this is to no benefit to itself. Even with the generation spike of 9.11 in December, the average generation charge for 2013 was only 6.64 as compared to the average for 2012 of 5.75. The increase in generation charge for the December and January billing months is an aberration. At this juncture, Your Honor, we'd like to illustrate how the supply chain works and how a continuing TRO or injunction severely disrupts it. The supply chain is a post-paid system, meaning the power had already been delivered to the customer who pays for it afterwards. It assumes that the fuel suppliers had delivered fuel to the GenCos, the GenCos had used that fuel and generated power, the NGCP had transmitted the power through its grid, and the DUs had distributed the power to its customers. To cycle the supply chain, the customer must now pay the distribution utility. The distribution utility then pays the taxes and the universal charges pertaining to the government. It pays the transmission company, then it pays the WESM for its purchases, and then the generation plants. And the generation plants pays the fuel suppliers approximately 60% for the fuel costs. And the DU keeps only 17.6% of the total bill. Your Honor, considering that the other respondents in this case did not cover the issue of the TRO, permit me to go to that issue ahead of time. We assert, Your Honor, that the TRO should be lifted and the prayer for injunction should be denied. The TRO should be lifted for petitioner's failure to establish, one, a clear and unmistakable right alleged to have been violated. Two, the alleged invasion of petitioner's right to due process. And three, the existence of grave and irreparable injury. The petitioners have no clear right to stop the collection of these pass-through charges, nor the staggered collection of the same. The declared state policies as provided in the Constitution and in the EPIRA Law are not a source of a clear legal right. Section 19, Article 12 of the Constitution on monopolies is not a self-executing provision. The due process clause in the Bill of Rights is not applicable. The Bill of Rights are intended to be safeguards against the state and cannot be invoked against a private entity. Secondly, there is no irreparable injury or damage. Sweeping statements of grave injustice is contrary to the rules of court, which requires that the violation sought to be prevented must be specified and proven. Petitioner's claims are essentially quantifiable and reparable, subject to exact mathematical computation, and therefore compensable through a refund. There is a speedy and adequate remedy available, that is recourse to the ERC under Section 45 of the EPIRA Law. We urge this honorable court to balance the interests and claims of the petitioners and the private respondents with the long-term interests of the country, the economy, and the public in mind, and not take a myopic perspective. On the rights claim, the petitioners assert general statements of policy in the Constitution and the EPIRA which are not self-executing ready for enforcement by the courts. Compare this with the clear provisions of the EPIRA Law passed by Congress in accordance with its constitutional mandate. The petitioners assume that the EPIRA Law, its IRR, the AGRA rules are unconstitutional. Balance this with the presumption of the validity and constitutionality of laws and administrative rules and the jurisprudence upholding similar automatic escalation rules. On the factual basis, the petitioner's allegations are general and unvalidated statements based on speculation and news accounts. Weigh this against the requirement that a TRO or injunction should only be issued when the applicant is able to establish a demonstrable prejudice of legal rights. The petitioners are foisting upon this honorable court to make a finding on factual issues pertaining to the complex and technical electric power industry, whereas we assert that it is the ERC which has the expertise and technical personnel on the power industry which should make that determination in the first instance. The petitioners assume and conclude that the increased pass-through charges are illegal and a product of collusion, whereas we have shown that 1.03 pesos pertain to the higher replacement cost of fuel and that the 2.42 pesos pertaining to SM, which have the legal presumption of regularity as the price determination methodology of the WESM was duly approved by the ERC. On the focal issue, under the EPIRA, one of the state policies is to ensure the quality, reliability, security, and affordability of the supply of electric power. The petitioners have focused only on the aspect of affordability or price. Balance this with our holistic approach, not merely affordability, but the entire aspects of quality, reliability, security, and affordability must be considered, and the supply chain must be made to work without disruption. Petitioners sought to stop the collection of the increased pass-through charges, which are quantifiable to the last centavo. Balance this with our assertion that these claims are capable of exact pecuniary estimation and are not irreparable and could be refunded if deemed appropriate by the ERC. More importantly, Meralco points out that the TRO or injunction will stop delivery of fuel to the GENCOs, and the unpaid GENCOs will likely stop delivering and power to Meralco, and Meralco will have insufficient power and will have to ration its power due to blackouts. The estimated unpaid fuel cost, Your Honor, is approximately 11 to 12 billion pesos. With the TRO, the generation charge is frozen at 5.67. Presently, there is sufficient supply for now, as January and February months are the lowest off-peak months in the energy industry. I'd like to advise this honorable court that for this January supply and February billing months, the generation charge is 5 pesos and 53 centavos, or lower by 14 centavos. Despite the fact, Your Honor, that the peso exchange rate has deteriorated by 2 pesos and 11 centavos, or almost 5%, from 43.21 to 45.32. With the summer months coming, demand will increase. It is expected that by March, it will increase by 8%, by April, 16%, by May, the highest at 17%, and 16% in June. On the other hand, look at the supply. The supply in Luzon will decrease by 2,147 megawatts as hydropower plants will become unavailable during the summer months. To pick up the slack, peaker plants, which are fueled by expensive diesel or bunker oil, must be asked to run. But it is not economically feasible to do so if the generation charge is frozen at 5.67. Consider that the fuel cost alone for bunker and diesel is approximately between 6.11 to 7.95 pesos, or almost 8 pesos. Certainly, Your Honor, we anticipate that there will be a shortage if this Honorable Court will not lift the TRO on this generation charge and fix it at 5.67 for these coming months. Dire consequences to the economy will be brought about by rotating brownouts, not to mention the likely loss of investors' confidence due to the perceived instability of our laws and regulatory rules. Brownouts, Your Honor, Meralco has been accused of using blackmail. Your Honor, the business of Meralco is distributing power. It doesn't generate power, but it distributes power. And it will distribute all the power that it can get. The supply of power is under the control of the GenCos. And this is influenced in turn by the supply of fuel that is delivered to the GenCos. By the way, Your Honor, we'd like to advise you that Meralco has received threatening demands from the Philippine Electric, from the WESM, NGCP, and approximately 6 GenCos, not only for the December bill, but also for the January bill, asserting that it is not covered by the TRO of this Honorable Court. Thus, Your Honor, we submit that if at all GenCos, NGCPs, and other beneficiaries should likewise be enjoined from collecting these pass-through charges from Meralco. Now we go to the issue of whether or not ERC committed a grave abuse of discretion in granting the staggering of the collection of the 9.10 increase in the November supply month. Your Honor, the letter request of Meralco of 5 June was not a rate application. It was an application for guidance to cushion the impact of the pass-through charges. Under the EPIRA Law and the implementing rules and the agro rules, Meralco has the right to charge it at one time. And if it wants to stagger it, it had to get the consent of ERC. The approval by ERC was done also in accordance with the agro rules and the amendment. And considering the necessity of addressing the needs of the industry on a real-time basis, we submit, Your Honor, that these rules are all valid, Your Honor. While Meralco could have imposed in full these pass-through charges, the request by Meralco and the grant by ERC to stagger the collection thereof could not have been committed with grave abuse of discretion, as the same is favorable to the consumers. It is not, Your Honor, the definition of grave abuse of discretion, Your Honor, is exercise of discretion, Your Honor, in excess or equivalent to lack of jurisdiction. Or it is an exercise so patent and so gross that it amounts to an evasion of a positive duty or refusal to enforce a duty enjoined by law, or to act within the contemplation of law. So despotic, in an arbitrary or despotic manner, and by reason, and it can only be motivated by reason of hostility or passion, Your Honor. And certainly, that cannot be said for the action of ERC in granting the staggered collection of this bill for the supply month of November. We also assert, Your Honor, that the remedy applied for by the petitioners is also inappropriate, Your Honor. One, they failed to exhaust administrative remedies because they should have gone to the ERC, Your Honor, which has the specific competence in that particular area. And also, Your Honor, it also violates the rule on the primary administrative jurisdiction of ERC. The matter involved in this matter, Your Honor, are intricate and complex issues pertaining to the power industry. It is the ERC, Your Honor, that had the personnel, the experience, the special knowledge with respect to this industry, Your Honor, so that they will be in a better position to handle the conflicting assertions of the different parties. Likewise, Your Honor, we assert that the issues raised are not justiciable. These are the very definition of what is a political question, Your Honor. They are questioning the wisdom of the EPIRA Law. And it has been said, Your Honor, that it is not, this honorable court do not sit in judgment to revise or revisit the wisdom of the law, but of the legislative action, but rather it is there to enforce the legislative will, Your Honor. To do so, to do otherwise will be to debase the separation of powers that is mandated by our Constitution in our Republican form of government, Your Honor. Now, with respect to the, Your Honor, I just like to just stress one point, Your Honor. With respect to our impleading of the other GENCOs, Your Honor, Nasecore has a prayer, Your Honor, for a refund. Refund of automatically pass-through charges that have been already collected and have already been paid by Meralco to the different recipients. And these recipients are the GENCOs, the government, and NGCP. And we assert, Your Honor, that it will be highly unfair that if, and unjust, Your Honor, if Meralco will be asked to refund this without, in turn, asking those who receive those amounts to pay those to Meralco, Your Honor. Time is up, Your Honor, and I will I'm ready to answer the questions of this court.
Thank you, Attorney Lazatin. We'll wait for Justice Feliciano before the justices begin their interpellation. But there is just a question here from one of the justices as to whether the newly distributed slides that you gave us on the thermo picking load would have been covered by the additional 10 minutes you were requesting, or whether that is the subject of Justice Feliciano's presentation.
No, Your Honor. Justice Feliciano will be cover the issue on public utilities, Your Honor.
Okay.
Your Honor, the issue on the Thermi Mobile, Your Honor, as well as the alleged 62 trading cap was introduced, Your Honor, by the amendment of the petition of Bayan Muna, Your Honor.
Okay.
And it was not covered in our original presentation and in our original...
But you are ready?
Yes, Your Honor.
For questions regarding those slides?
Yes, Your Honor.
Okay, thank you very much, Attorney Lazatin. We'll now hear from Justice Feliciano. If the bailiff will kindly make sure that Justice Feliciano is comfortable, kindly, we will be very pleased if a seat can be given him, bailiff.
May I please talk sitting down?
Yes, please, Justice
Madam Chief
Feliciano, and
Justice.
kindly make sure that he also has his glass of water with him. Thank you, but before we allow Justice Feliciano to start, please take your seat, Justice Feliciano. I'd like to make up for an oversight I made in the last oral argument, I'd like to thank Secretary Petilla and Chairman Ducot, as well as the commissioners, for being sensitive to our request that they be here. Thank you for your presence. Justice Feliciano, please proceed.
The Honorable Chief Justice of the Philippines, the Honorable Senior Associate and Associate Justices of the Supreme Court, may it please this most honorable court. This afternoon, I propose to focus on the constitutional law issues raised by the petitioners. My preceding colleague has spoken about the factual context of the dispute. I propose to deal only with the technical, constitutional, or legal issues. The petitions were triggered by the sharp increase in consumer electric bills for the supply months of November and December 2013. In particular, the petitioners question Meralco's pass-through of generation charges shown on its bills to its customers. However, rather than contesting the matter before the ERC, as the law allows, petitioners came directly to this honorable court. And here they challenged the constitutionality of sections 6 and 29 of the Electric Power Industry Reform Act of 2001, or EPIRA, because it declares that, first, power generation and supply are not public utilities, and second, they are not subject to price regulation by the ERC. My first suggestion, if Your Honors please, is that the petitioners fail to meet the requisites of a valid constitution. The petitioners fail to meet the requisites for a constitutional challenge that this court has laid down in innumerable cases. Insofar as Section 29 of EPIRA is concerned, the petitioners admitted in the January 21 hearing that no actual case as regards the power suppliers had been brought because the latter admittedly did not play any part in the price increase subject of the petitions. The plea to nullify Section 29 is, I respectfully submit, purely hypothetical and is effectively a petition for declaratory relief, and over which the court ordinarily has no original jurisdiction. However, or rather moreover, the power suppliers have not been impleaded in the petitions. To rule on the constitutionality of Section 29 of EPIRA would therefore amount to a denial of their right to due process. On the other hand, if Your Honors please, the petitioners' attack on the constitutionality of Section 6 fails to meet the requirement that the constitutional issue be the very lis mota of the case, the court will not pass upon a constitutional question even if otherwise properly presented by the record, if the case can be disposed of on some other ground through the application of a statute or of general law. The reason for this rule is, of course, traceable to the doctrine of separation of powers, which enjoins upon each department a proper respect for the acts of the other departments. As explained by this honorable court in People versus Seaton, I quote, "The policy of our courts is to avoid ruling on constitutional questions and to presume that the acts of a political department are valid in the absence of a clear and unmistakable showing to the contrary. To doubt is to sustain. This presumption is based on the doctrine of separation of powers, which enjoins upon each department, and may I stress each department, a becoming respect for the acts of the other departments. The petitions may be disposed of without passing upon the constitutionality of sections 6 and 29 of EPIRA. The petitioner's allegation that the ERC and the Department of Energy gravely abused their discretion in allowing the price hike can be fully adjudicated by applying the provisions of the EPIRA, which, after all, was the culmination of more than 7 years of public hearings and floor deliberations in Congress. It is a law that has been carefully studied and crafted by Congress, with clear and unambiguous standards to guide both the regulators and the courts. My second point, if Your Honors please, is that the petitioners have no cause of action to attack the constitutionality of sections 6 and 29 of EPIRA. For a constitutional challenge to prosper, it is important that the legal right asserted be a specific, operable legal right, rather than a comprehensive statement of constitutional policy that requires implementing legislations. Here, petitioners cite no constitutional provision that has been clearly violated by the respondents. Instead, petitioners rely on Article 12, Section 6 of the Constitution. And this is the section which says the use of property bears a special function, and all economic agents shall contribute to the common good, and so forth. I don't think I need to read the rest. The problem is that this provision is not self-executory and does not embody a judicially enforceable constitutional norm. Article 12, Section 6 is a comprehensive guideline for the legislative exercise of police power. The reasons for denying that a constitution is from an alleged breach of broad constitutional principles can be found in basic considerations of due process and the lack of judicial authority to weigh. Here I am quoting into the uncharted oceans of social and next to touch on the concept of utility. The petitioners that the power generation sector should be declared as consisting of or as embracing public utilities and thus subject to price of regulation. Public utility is of American origin, that I'm sure you all know, Your Honors, please. It was introduced into our legal system in 1913 by Act number 2307, passed by or enacted by the Philippine Commission. The concept can be traced back to the 1600s from the commentaries of Lord Matthew Hale of the United Kingdom, where Lord Hale declared that when public property becomes, quote, affected with a public interest, unquote, it ceases to be of iuris privati only. This statement of the law was adopted by the United States Supreme Court in the seminal case of Mann versus Illinois, decided in 1876. After the U.S. flag came to the Philippines, our own Supreme Court adopted this general statement. Yeah. The focus of Mann and subsequent cases has always been regulation, the power of the sovereign, of the state, to regulate private property. Thus, notwithstanding the rights associated with private ownership of property, sometimes a private owner's business becomes, quote, clothed with the public interest, unquote, and ceases to be solely or merely or exclusively private. The government must then assume a substantive role in protecting that public interest. There are two broad fundamental principles which justify governmental oversight of public utilities. First, of course, there is the public interest aspect. The services offered by the private entity involve and affect the well-being of society at large. In other words, it is an industry that is, quote, clothed with the public interest, unquote. The failure of the sovereign to regulate the operations which affect or impact upon public interest may generate prejudice and harm for the public interest. Secondly, the technological aspects of the industry, such as the private power industry, are often such that a single provider is able to service the overall demand at a lower total cost than any combination of smaller entities. Competition cannot thrive under those conditions. Eventually, all firms or most of the firms will exit or may fail. The entities which survive are frequently called natural monopolies. And like other monopolies, they have the potential power to restrict output and set prices at levels higher than might be economically justified. This potential power of private entities in industries affected with public interest provide the justification for government to intervene in a market insofar as it may be necessary to achieve public benefits that the market fails to bring about on its own. The United States Supreme Court in Cantor versus Detroit Edison Company said, and I quote again, "Public utility regulation typically assumes that the private firm is a natural monopoly and that public controls are necessary to protect the consumer from exploitation." In the Philippines, public utility is frequently or is commonly defined as, and here I quote again from JG Summit Holdings, Inc. versus the Court of Appeals, quote, "a business or service engaged in regularly supplying the public with some commodity or service of marked public consequence," unquote. To constitute a public utility, the facility must be necessary for the maintenance of the regular lives and occupations of the general community. But that is not the only criterion. That a business offers goods or services that promote the good and serve the interest of the public does not automatically make it a public utility. Public use is not synonymous with public interest. The term public utility implies, firstly, public use, meaning the use by the public that is allowed voluntarily by the owner of the business. Meaning that the commodity or service is open to access by the indefinite public and is not confined to limited numbers of privileged individuals. Secondly, the term also implies service to the public. That is to say, there must be an intrinsic necessity for the service or the commodity provided for the continued maintenance of life and the regular, ordinary occupations of the public. The legal questions involving public utility regulation, both in the Philippines and in the United States, always revolved around the power of the state to regulate, a power that is no longer questioned today. Today, the issue is not whether the state may exercise regulation. It is rather whether or to what extent the state should exercise such regulation. I respectfully submit that this question is a matter of public policy, best addressed to Congress rather than to this honorable court. It was in fact a policy question of whether or not to install free competition instead of a monopolistic environment for power generation, which Congress definitely resolved when it passed the EPIRA Act in 2001. Now, I would like to talk a little bit about the EPIRA, although I assume by now you have read the EPIRA probably number of
Yes.
times.
In fact, we would be very appreciative, Justice Feliciano, if you can wind up your presentation, because we are now interested to go into the interpellations.
Yes, yes, Your Honor, please. If we apply the criterion laid down in Philippine jurisprudence, that the principal determinative characteristic of a public utility is that of service to or readiness to serve an indefinite public or portion of that public, such that a legal right to demand and receive the services or commodities is created, then the inevitable conclusion will be that the generating companies, the GenCos that Mr. Lazatin was talking about, are not public utilities. The energy produced by the GenCos are only available to distribution facilities, distribution companies. The GenCos clientele is too narrow to be considered the public itself. Unlike distribution public utilities, generating companies serve the public only incidentally. It must be noted that electrical energy produced by the generating companies is in such a form and under such technical circumstances that only distribution utilities and retail electricity suppliers and not the public at large are equipped to receive and transmit over long distances. Secondly, the public does not have a legal right to demand electricity directly from the generating companies. The public's right to demand and the correlative duty to supply electricity lies with the distribution utilities, which is to be expected considering that the generating company's output cannot be directly delivered in its original form to the distribution utilities and users. I propose to stop here, even though I'm not quite through with what I stating this, but if Your Honors, please.
Yes, Justice Feliciano, it might be good for us to end this discourse on public utility, because it really is an argument addressed to the generation companies more properly. So we may begin our interpellation, and Attorney Lazatin should be here so that we can be more efficient in the process of shifting the answers from you to Justice Feliciano. Justice Leonen will start the questions.
Good afternoon, Counsel.
Good afternoon, Your Honor.
First, I would like to say that I am happy to have heard again from Justice Feliciano. Many of us have read many writings of his, especially for the court. I remember that he is the ponente of the Ayer Productions case, a case that has become important quite lately for the court. And also at the WTO, he has been the ponente of a lot of important cases, including the EC asbestos case, where there was a new interpretation of Article 3 of the General Agreements of Tariffs and Trade. So if Attorney Lazatin will not mind, I will reserve for him the more difficult questions. And for now, I hope you can contend with my easier questions this afternoon. First, maybe just to get this out of the way, shouldn't you assume that this court can take a long view, meaning to say that it does not look myopically at issues that are brought before it?
Your Honor,
Perhaps just respond to the question. can we not assume that this court can take the long view and not only respond myopically to the issues presented to it?
Your Honor, precisely I would want this court precisely to take a long view rather than a myopic view, Your Honor.
In deciding to issue the TRO, that we were very aware that there was a need that electricity supply should have the quality, reliability, and affordability required to it by law. You would agree with me that that could have been the view of this court?
Your Honor, I can assume that that is the
and
view
that
of the court,
perhaps
Your Honor.
we should also assume that being the Supreme Court of this republic, that even though the issues may be complex and sometimes technical, when we do need jurisdiction, then we have to deal with the complexity of the case and the technicality of that particular case, when the court can take jurisdiction over that particular issue.
On the average, Your Honor, I would say that it is the proper administrative agency in the first instance, Your Honor.
No, my question is for issues which are necessarily complex and technical that reach this court and we can take jurisdiction. Can we not assume that this court must deal with the complexity and technicality presented?
Of course, Your Honor, it can, but I'm coming from the point
with
of
me?
view, Your Honor, that is not a trier of facts.
Of course, we
and
agree
that
with that.
if there is, like here in this particular instance, Your Honor, there are several technical issues on the operation of the WESM. I just felt, Your Honor, that it would have been better, Your Honor, if it were the administrative agency, the expertise, the personnel, and the experience who would do it in the first instance, Your Honor.
Yes, your position there is very clear. Also, that quasi-judicial, that the fact that there is a quasi-judicial agency does not mean that the court has no power of review over that quasi-judicial agency. Is that not correct?
That's correct, Your Honor, but all I'm saying, Your Honor, is that the appropriate time for the court to review the decision of the quasi-judicial agency, the most appropriate time, Your Honor, is after this quasi-judicial agency with that particular expertise in that field had already gone through and shifted through the different arguments, Your Honor.
A position that you have taken, which is also very clear to us. Just to clarify some of the more basic points, because
Yes, Your Honor.
there were some statements made by you, perhaps because it was simply a 30-minute presentation that was quite too general, and I am just interpolating
Yes, Your Honor.
as to whether it can be more nuanced a little bit. Now, the price, of course, of a good, especially that of electricity, actually comprises of a lot of things. Is that not correct? It congeals a lot of questions. While it is a single number for the consumer or for the supplier, it is in fact the result of many, many things. Is that not correct?
I agree, Your Honor. In fact, the unbundling
Yes.
of the rates that was mandated by EPIRA is one of them, but even just with respect to generation, transmission, there are of course different components.
And it is also an important signal to the producers and investors. Is that not correct? Price is a good signal for producers.
Yes, Your Honor, that is the precisely main indicative point that the businessman or the economist will take a look at if a business is worth getting into, Your Honor.
Yes, and also that it determines will consume and at what amount in terms of their own consumption.
I agree, Your Honor, except that with respect to electricity, the demand is rather inelastic to the extent that some consumers have some leeway. Yes, Your Honor, maybe like, for example, switching off your aircon and so on, but for certain basic necessities like your lights, your refrigerator, Your Honor, the demand for electricity to that extent, Your Honor, is quite inelastic.
That was my next question regarding the demand, which is inelastic, and therefore, in certain cases, the consumers do not have a choice. And would you agree with me that in terms of the legal structure of this country, that most of the costs are passed on to the consumer?
Yeah, like
Universal
any,
charges, stranded costs, VAT, looking at exploratory areas, feed-in tariffs, all of these are passed on to the consumer.
that's right, Your Honor. That is the precisely one reason why our electric power rates are high is because, one, there are so many taxes, and these are all of these different charges. Your
And
Honor.
per se, the amount that comes out of it is really a policy question, meaning to say that whether to pass it all on to the consumer or whether the government should subsidize, like in many countries that you were about to present but did not, Malaysia, etc. It's really a policy choice of government. Is that not correct?
That's correct, Your Honor.
And that our jurisdiction is only with respect to the Constitution and the statutes, as well as the implementing rules and regulations of the statutes, and in this case, maybe ERC and the WESM rules in relation to an actual case. You would agree with that?
I'm sorry, Your Honor, I didn't quite...
Would you agree that our jurisdiction is not to look at policy, but rather to look at how to interpret the Constitution in relation to the statutes and implementing rules given an actual case?
That's correct, Your Honor.
Yes. But in order for us to be able to do that, we need to have a context of the issues that are created
Of course,
before the
Your
court.
Honor.
Yes. And you would agree with me that the sectors in the power industry are interrelated with each other. You put it there, the generation, the transmission, the distribution, etc. It is not discrete, but they have interrelations with each other.
Yes, Your Honor, it is precisely a supply chain, Your Honor, that goes from the fuel, Your Honor, that is burned to generate the power, and then that is passed on, carried through high voltage wire, and then to the distribution, Your Honor, where it is now converted
Okay.
into lower voltage by the substations.
Yes, and it was
transformers. Yes,
quite astute and very wise of you to include another sector which is not usually in the traditional presentation of the power sector, which is the fuel sector, which is of course not governed by the EPIRA. Are we correct?
That's correct, Your Honor.
Yes.
But here, Your Honor...
And you would agree with me that in terms of the price increase in your presentations, not only here, but also in Congress, that you have attributed much of the increase of the 4.1 peso increase to the price in the spot market. Is that not correct?
That's correct, Your Honor.
Yes.
In our analysis, Your Honor, we pointed out that
And we will go into this later.
2.4
But the
centavos.
bilateral agreements that you have with other PSAs, we'll go to this later, more in detail,
Yes, Your
just
Honor.
generally, that the bilateral agreements you have with your, in the power supply agreements, do have an effect on the behavior of the spot market. Is that not correct?
Yes, Your Honor, to the extent that
Would you
the
agree with
spot
me that
market,
you
Your
are-
Honor, is only supposed to be for the uncontracted volume, Your Honor.
Yes, but later on we will see the relationship. But again, as we said, we will go to detail. I'm just trying to clarify a few points. You are not the only respondents in this case, correct?
Yes, Your
Yes,
Honor.
and the respondents in this case is the ERC, the Department of Energy,
That's correct,
and
Your Honor.
alongside the private respondent, which is Meralco. Is that not correct?
That's correct, Your Honor.
Yes. The reading of the temporary restraining order issued by this court on December 23 and confirmed by the court and bank as soon as it convened again in January. Your reading there is that there will consumers will not pay, will not be free from payment of generating costs. In other words, we did not say in the TRO that no generating costs will be paid by the consumer. Is that not correct?
That's correct. Our
Yes.
understanding is that the
And
generation
that this
charge...
was a TRO, not an SQA. Temporary restraining order effective upon its issuance rather than an SQA that will work its way back to December 1 of 2013. Is that not correct?
I agree, Your Honor.
And therefore, would you agree with me that Meralco had collected already until December 23? Just that fact alone.
Yes, Your Honor, because
Yes.
by the time the TRO was issued, some of the bills were already issued to...
So it is safe to assume there was some payment that was made by some consumers to the tune of about 5 pesos or more, and that 5 pesos, 5 point something pesos, which was paid in our December bill. By the way, many of us paid our full bill, had already been paid to the generating companies. Is that not correct?
That's correct, Your Honor. And if...
and the 11 to 12 billion that is owed to generating companies, this value, this price, includes the spot market costs. Is that not correct?
That's correct, Your Honor.
So it's 11 to 12 billion, including the times when the market cleared at 62. Is that not correct?
I will correct the figure, Your Honor. The total amount of the deferred collection, Your Honor, amounts to 18 billion, Your Honor.
Yes, but 18 billion, which
About
includes
more-
the price in the spot market when it cleared at 62. Is that not
That
correct?
it's included in that.
And there
figure.
is no generating company, there is no power plant whose variable cost is 62. Is that not correct? It will be 10, 12, 42, 45. I think for Bawang or Limay at certain points it was 42 or 45. 62 is only the maximum clearing price. Is that not correct?
Your Honor, I'm not familiar with the other charges of the other GenCos. I'm familiar only with those with which Meralco has contracts. For TMO, Your Honor, my recollection, Your Honor, is that the price is about 8 to 10 pesos, Your Honor.
Yes.
But the indicative price when the contract was signed was
So when the market
11.26.
clears at 62 and the actual price is about 8 pesos, then therefore there is a revenue that is given to the others that participated in the spot market other than the bilaterals. Is that not correct?
That's correct, because that's how the WSM market
And that is the 18
was,
billion that you are supposed to owe to the generating companies.
Your Honor, maybe portion of that is
Yes.
part of the WSM,
So a portion
and part
of that,
is
a portion
also...
of that is really profit rather than meeting the actual cost. Is that not correct?
that's correct, Your Honor.
Yes, but you would agree with me that it is all right for companies to profit under our state of affairs, correct? There is nothing unconstitutional with profit.
There is none, Your Honor.
Yes. Also, that you mentioned that there were several threatening demands made of you to pay up for your December and January generating costs. Is that not correct?
Yes, Your Honor.
Yes.
More recently,
But in the
January.
TRO that we issued, it was very clear that the matter that was the subject of the TRO was that in the December 5 and the December 5 letter of your company and the December 9 order of the ERC. Would you agree with me that that is the tenor of the TRO?
Yes, Your Honor.
Yes. And the December 5 letter did not mention the December charges, did it?
No, Your Honor.
Or the January charges, did it?
No, Your Honor, because
Yes.
they were not yet then ready.
Yes. In other words, perhaps as a response to the threatening demands, it is always your option to interpret the TRO by yourself or to clarify the scope of the TRO. Is that not correct?
That's correct, Your Honor.
Yes.
In fact, we
By
were
the way-
about to file a clarificatory motion, Your Honor, but we knew that the Supreme Court was in recess, and we did not want to take any advantage of the
Well,
absence.
we are
Your
not
Honor.
in recess now, Counsel, are we?
No, Your Honor.
Yes.
And in fact, we are going to file a motion very quickly, Your Honor, after these oral arguments.
Well, not too quickly. Can be tomorrow if you want. Yes.
I think we're ready to file it, Your Honor. In
Yes.
fact, we were supposed to file it earlier today, Your Honor.
Yes.
But
And just to clarify, this court doesn't issue preliminary injunctions. Is that not correct? We
I'm
do
sorry.
not issue preliminary injunctions because TROs in lower courts are effective for 20 or 60 in the Court of Appeals. Therefore, there is a need for a writ of preliminary injunction, but in this court, a TRO is depending on the court en banc. Is that not correct?
the TRO issued by this court is for 60 days, Your
60
Honor.
days, yes. And when we extend our TROs, it will still be a temporary restraining order, not a writ of preliminary injunction.
That's correct, Your Honor.
Yes. So in any case, justiciability is put in issue. And I hope you wouldn't mind, although this was covered by Justice Feliciano, that I ask you, because I think these are easy questions. And
Yes.
again, as I said, I will reserve my difficult questions for Justice Feliciano.
Thank you, Your Honor.
Yes. Yes. All my questions are going to be very easy. December 5, you filed a letter with the ERC. Is this not correct?
That's correct, Your Honor.
Yes. But assuming that the automatic automatic recovery of generation costs regulation is valid and constitutional, let us assume that for the moment, for purposes of my next question. You could have opted to automatically simply charge generation costs. Is that not correct?
That's correct, Your Honor.
Yes. But you filed with the ERC. Is this not correct?
We filed with the ERC because
Yes.
it is the ERC that regulates the rates, Your Honor. And
So in effect, you are asking the ERC for a look into the generating cost as well as the modality of payment of the consumers, as well as, of course, the last one was that you can pass on some of the carrying costs.
that's correct, Your Honor,
Yes.
because there will be a carrying cost to Meralco if it will effectively advance to the gen cost, that portion that we will not be able to collect, Your Honor.
At this point, may I just show you a slide? This is slide number 52 for my assistant. It's not with you, but it's just for purposes of our presentation. This was derived from the RTD report of the PEMC.
PEMC,
Yes, the RTD report of the PEMC. Of course, you know what RTD would mean, Council. Can you please?
yes, real-time dispatch, Your
Yes,
Honor.
real-time dispatch, and this is historical by year. And you would see that the rate that was about to be imposed upon the consumer was extraordinarily high. Is that not correct?
We agree, Your Honor. That's why we brought it up to the ERC.
ERC, extraordinarily high, meaning to say it was not within the ordinary band, even including the spike that happened sometime in 2010, which was at 6. This one was already at 9. Even the spikes that happened as a result of the Malampaya shutdown in the past, this was extraordinarily high.
Agreed, Your Honor.
Yes. And December 5 was a Thursday, and according to the petitioners, and in fact by the pleadings that have been filed with us, the ERC acted on December 9, which was a Monday. Is that not correct?
That's correct, Your Honor.
And the ERC did not do any inquiry except to look at the letter and perhaps to consult with Meralco. Is that not correct?
Yes, Your Honor, but this is
By filing the
this is
letter-
an action that is favorable to the consumers, Your Honor.
By filing the letter with the ERC, did you not waive the automatic increase allowed to you by the regulation?
Effectively, Your Honor, precisely we wanted to stagger
filing
it
with
to
the
cushion
ERC.
the impact on the consumers, Your Honor. That was precisely the objective.
By filing with the ERC, did you not want the ERC to take a look at the rate, at the deferment, and at the carrying cost that was going to be charged at the consumer? You filed the letter. Did you not want the ERC to take a look at the costs, at the carrying cost, and at the deferment?
Your Honor, it was more for asking for a permission for the deferment and making, intimating that we would also want to file or intimating to the ERC that we would want to file a petition later on, Your Honor, for the carrying costs. If the question is whether we wanted the ERC to, or we filed a case to question the
No, maybe I'll put it this way. You were not just informing the ERC to defer the cost. You were asking its permission to defer the cost. Is that not correct?
Yes, Your Honor, because we did not, as I understand it, Your Honor, there is no provision in the rules that will permit the staggering, Your Honor. It's either a
Because-
pass-through for that month, Your Honor, you put it in the billing month, and that's it.
Because you've waived automatic pass-on of generating cost, because you wanted the ERC to take a review or to take a look at the rates as well as the deferment as well as the carrying cost, don't you think that there should also have been notice to the consumers in line with the two precedents that we have? This is the FDC versus ERC and the Nasecore versus ERC case.
Your Honor, this is not a rate application. I would agree, Your Honor, if what we filed with the ERC is a rate application. Your Honor, there are only 5 instances in the EPIRA where the rate applications or applications for fees are provided for. And this is for transmission, the universal charge, distribution, the ancillary services, and the lifeline rates. All the rest, Your Honor,
It says generating
can be,
cost.
yes, Your Honor.
Yes.
Generation costs are not covered by
In the case of Nasecore versus ERC, as well as in FDC, the court there held that any application to increase should have notification to the consumer. Is that not correct?
because the IRR at that time provided for it, Your Honor.
So it was amended in order to provide for automatic generating costs.
That's right, Your Honor. So though that's
But
no
this
longer applicable.
exception that you availed of is not in the regulation. Is that not correct?
So the staggering
Therefore,
is
we
not
go back to the original rule, which is that there should be notice to the consumer.
No, Your
because
Honor.
the EPIRA requires transparency.
Your
Is that the
Hon-
correct interpretation?
That's I take issue with this, Your Honor, with respect to that, because the IRR at the time of the first Nasecore case, Your Honor, was already amended, so that's out. Okay? Now, Your Honor, we could have passed through the whole generation charge for that month. But what is not provided in the rules is, one, that we can stagger it, Your Honor.
Can
And
you pass
second,
on
and in staggering
automatically?
in staggering it, Your Honor, we wanted to be sure that we will be able to recover the carrying costs, Your Honor.
Yes.
And we had a specific proposal on how it was going to be staggered.
Yes. Can you pass on automatically carrying costs?
I don't think so, Your Honor.
You
We
don't
will have
think
to
so?
apply.
And for carrying costs to be properly computed, it needs to take a look at the principal being the generating cost. Is that not correct?
I think it will be, the principle is what we have advanced, Your Honor.
Yes. And in the letter that you gave, December 5, you asked for carrying costs to be charged to the consumer from ERC. Is that not correct?
That's correct, Your Honor.
Yes. Does that not need prior notice to the consumers in accordance with our earlier jurisprudence?
When, Your Honor, when we file for that additional carrying cost, Your Honor, ERC precisely told us, file an application.
So it was
there
not-
will be a hearing for that application, Your Honor.
Oh, that should be what ERC would have said. That ERC should have said, file the right petition. Did it actually do that?
It intimated it in the letter reply, Your Honor. That's a subject of
December
a different
9?
application.
In
Yes, Your
its December 9 order?
Honor.
I am not sure, Counsel. But did you ask for carrying costs in your December 5 letter?
It was a, no, Your Honor, it was a reservation that, because we did not know at that point in time.
I'm sorry,
Your Honor,
Counsel.
what
I think we all have the same copies of the December 5 letter. Maybe just cover it in your memoranda whether, in fact, there was a request for the carrying cost in the December 5 letter. Okay. Let's move on to another topic, and this is the constitutional provisions that are involved. Of course, in reading the Constitution, all of us agree that we do not isolate a provision and only read that provision by itself. Is that not correct?
That's correct, Your Honor.
Yes. And that we have to take all provisions together in order to understand the nature of the provision as well as the meaning or how we construe meaning into a particular text within a particular provision. Is that not correct?
There are some, Your Honor, that had to be related, but there
Yes. It's because it's an entire constitution that
Yes,
we are
yeah.
construing anyway. Is that not correct?
that's correct, Your Honor.
Yes. And this court does not have jurisdiction only to read the Constitution by itself, but if there are statutes that are already enacted, helping us or guiding us to interpret the provisions of the Constitution, as well as implementing rules and regulations, then we take the interpretation also inclusive of the statutes and the implementing rules and regulations. Is that not correct?
Your Honor, all laws, all administrative rules, Your Honor, have to be interpreted and gauged against the Constitution, Your Honor.
Yes. Let us take a look at Article 12, Section 19 of the Constitution. And this is the actual provision. It has two sentences. the state shall regulate or prohibit monopolies when the public interest so requires. The word state there in the first sentence, does that refer only to the legislature?
No, Your Honor, the state, it could be the executive likewise, Your
Or
Honor.
the judiciary?
Or the judiciary, Your Honor.
In a
the
proper
decision.
case?
Yes, Your Honor.
Yes. Second sentence states, no combination in restraint of trade or unfair competition shall be allowed. There is no as may be provided by law. Is that
That's
not correct?
correct, Your Honor.
And therefore, a while ago you said that this is not self-executing. Did I get you correctly?
That's correct, Your Honor.
How come?
Your Honor, there has to be, with respect to monopolies, Your Honor, there has to be some provisions of the law that will flesh it out, Your Honor.
But this is a provision in the Constitution. Like,
That's right,
no
Your Honor.
person shall be deprived of life, liberty, or property without due process of law. We do not need legislation in order to interpret every word that is in that clause. Is that not correct?
Yes, Your Honor, but with
No
respect
combination in restraint of trade or unfair competition shall be allowed. For the court to be able to know what this means or to declare what it means, which is part of judicial power, in an actual case, of course, I would agree with you there, that this particular provision by itself can already be interpreted by the court. Is that not correct?
it can be interpreted by the court, Your Honor, but precisely legislation is needed, Your Honor, to flesh it out. And in fact, there is a pending legislation, Your Honor, with respect to the Fair Trade Competition Commission, Your Honor.
But actually there is. There is what is called the EPIRA. There is what is called the power of the ERC defined in the EPIRA to stop abuse of market power.
Agreed, Your Honor.
Yes. There is the ERC regulation that was passed
I am saying, Your
on
Honor,
competition.
I am saying, Your Honor, that this particular law, this particular provision of the Constitution, will have to be, you have to look into the particular details of the EPIRA law and the implementing guidelines as well as the rules on competition and market
Yes.
abuse of power, you know, to interpret that, Your Honor.
And in an actual case, for this court to actually determine whether those laws and the implementing rules that implement that statute is consistent with the interpretation of the Constitution.
That's correct, Your
Yes,
Honor.
because that is what is called judicial review. You would agree with me, counsel.
That's right, Your Honor.
Yes, and just very quickly, this is not the only provision that exists in the Constitution that can advise the court as to what the second sentence means. No combination in restraint of trade or unfair competition shall be allowed. You have to take it in the context of some of what you have called non-self-executing provisions, or what some writers have called hortatory provisions. For instance, Article 2, Section 9 provides for a goal of the national economy: full employment, rising standard of living, and improved quality of life for all. Okay? Then you have Article 12, Section 1. The goals of the national economy, equitable distribution of opportunities, etc. Then you also have Article 3, Section 1, which states equitably diffusing wealth and political power. And then Section 2 also, which actually says that economic opportunity should be created based on freedom of initiative and self-reliance. So these provisions, standing alone by themselves, would be self-executing. Is that not correct?
Your Honor, my issue, Your Honor, is this. Can these general
No,
provisions...
perhaps we can just
Your Honor,
focus on the question in order for us to clarify certain points so that we can actually direct our opinion in this particular case. So
Your
the
Honor,
question was,
that we
these
raised-
sections are standing alone would be self-executing, not self-executing. Am I not correct? But standing with that provision in Article 12, Section 19, means something.
they could mean something, Your Honor, but can they be the basis for a clear legal right to get an injunction? Because if they are, Your Honor, believe me, all of the lawyers here present, Your Honor, can get an injunction on any case if they rely on those general provisions of the Constitution.
I don't think so, counsel. It depends on the ruling of the Supreme Court, with respect to each particular case and each actual controversy, and it does not help for you to exaggerate.
No, Your Honor, our point of view in raising that is precisely in relation to whether or not there is a clear legal right for an injunction or a temporary restraining order. We assert that for an injunction, there has to be a clear legal right, Your Honor.
A point that you have clearly made, and we are understanding of your position. We understand your position, and of course, you do not expect the court to accept hook, line, and sinker your position. I think the role of oral arguments is also to test that,
Yes,
based upon different perspectives, to see how other perspectives might fit in or might be better, or might be the judicial way of actually reading certain provisions. Is that not correct?
I understand that
Yes.
completely.
So I hope you will excuse some questions because it will not be in line with what you want to hear from the court. Is that not correct?
That's correct, Your Honor,
Yes.
and please
And this
forgive
is
me
just
if I am also...
interpolation, which does not mean that this is the position we're taking.
I
To be
understand that, Your
judicious about an issue, we have to explore and examine very carefully your interpretation of the provisions. Is that not correct?
I understand that.
Yes, and
Your
I
Honor.
understand fully your position as an advocate, but I hope you understand the position of justices,
Yes,
because
Your
we have to rule on this particular issue.
I understand that
Yes.
completely.
And
Your Honor.
I hope you will forgive me. I have quite a number of questions, and I would like you to answer responsibly to the questions. We know your argument, you have advocated, your oratory was very well received, but we are interested in specific answers to specific questions because this is what is bugging us. That's why we are asking you, so that you can clarify for us.
I will
hope
try
that-
my best to
Yes.
answer your question.
You mentioned natural monopoly a while ago. Can
Yes,
you
ma'am.
define for us what a natural monopoly is?
Your Honor, a natural monopoly is classic, Your Honor, would be the distribution is that because of the nature of the business, Your Honor, as I mentioned, it does not make any sense to have two sets of poles in the city, Your Honor, when one will do. It is not a wise allocation of resources, and that it is in the business setting, Your Honor, you only need one. In the same way, Your Honor, that, for example, you only need, for, depending on the size, one airport, Your Honor. It will be, or for that matter, Your Honor, usually you will only need one ice plant before, Your Honor, or one slaughterhouse, Your Honor.
But isn't the modern view now in economics, it depends on the cost.
That's right, Your
If
Honor.
it will help the consumers to build a second pole, because the one that brought the first pole, I'm not saying Meralco, just in order to respond to your question, the one who brought the first pole is charging exorbitant rates. And the one with the second pole, including the construction of the second pole, have costs which are infinitely lower and more closer to market price.
But that is precisely what they call the regulatory consensus, Your Honor. You are allowed to have a natural monopoly, but you will be regulated. That's precise, because otherwise, Your Honor, you're correct, Your Honor. It's
Yes.
just market forces, but then it is a wasteful use of resources, Your Honor.
Not if there is constructive destruction that consumers will go to the second pole rather than the first pole. Then the resources will be more efficiently allocated. But let me proceed. Isn't it Meralco's legislative franchise, and this I'm just asking as a question, as a curiosity, isn't it Meralco's legislative franchise that makes Meralco a monopoly for distribution in a particular area?
That is the essence, Your Honor, of a franchise. You're
In other words,
exclusive
isn't the
within an
legislative
area.
franchise the cost of the cost CAUSE of the natural monopoly?
That is also the cost, Your Honor, but also the nature of the business itself, Your Honor.
And isn't it, or would it not be more prudent in a modern times to say that a public utility is a business that is affected with public interest and therefore more heavily regulated, but not necessarily that it should always get a legislative franchise?
Your Honor, that's precisely my understanding of the distinction between a public utility company and a public service company, Your Honor. But, and to my mind, Your Honor, it is Congress that makes the determination whether one should be a public utility requiring a franchise, Your Honor, or whether one is just a business affected with public interest because it does public service.
I'm just curious, counsel, in the law that gave the franchise to Meralco, what provision there cannot be, what provision of regulation there in the whole law that allowed Meralco the franchise? I'm sure that you have taken a look at it, being Meralco's counsel for quite some time, I would assume. That is still necessary to be in a separate franchise, given that a government actually regulates distribution companies in many different ways, environmental, the ERC is there because of EPIRA, etc. So what does the legislative franchise, what is it for, in other words?
My understanding, Your Honor, for all legislative franchises, Your Honor, is to primarily give you some exclusivity within a particular area. It imposes what your rights are as well as imposes on you
Perhaps in
certain
the
obligations.
memoranda you can actually show us the provision in the Meralco's Republic Act, which actually says that there can be no entrant to the area other than that company, that it is prohibited. But in any case, perhaps...
Yes, usually you...
Yes.
Yes, Your Honor.
We
please,
can
we will do that.
continue. But Meralco is unique among all distribution utilities. Would you not agree with me? It is unique in the sense that its franchise area is quite big.
That's correct, Your Honor.
In fact, it is the combination of three different areas that existed separately before. Is that not correct?
That's my understanding, Your Honor.
That's why in ordinary parlance, you are said to have a mega franchise because of the area that was given to you.
I've heard that term used before, Your Honor.
Yes, so 9209 was an amalgamation of three different pieces of legislation covering three different areas and coming into Meralco. Is that not correct?
That's my understanding,
Yes.
Your Honor.
Why did the other areas choose to be covered by Meralco, counsel?
Well, there is, Your Honor, I can only surmise. I don't really know the reason, Your Honor, but it can only be for efficiency's sake, Your Honor.
Yes, because Meralco then was thought to provide good service, I assume.
At that time, Your Honor, my recollection is that the power industry, Your Honor, is everywhere it was located was an integrated one. They
Yes.
produced, they generated their own power, they distributed it, and they transmitted it within their own area. We didn't have a national grid at that time, Your Honor.
So in essence, counsel, we can say that distribution utilities are actually competing with each other in the sense that, of course, after their legislative franchises will expire, one can poach on the area of another, provided, of course, that they provide good service, good prices, and so on and so forth. That there is that competition among distribution utilities. Am I not correct?
I am not sure, Your Honor, whether that is quite accurate because right now, Your Honor, as it is designed by Congress, Your Honor, each distribution utility has its own franchise area, Your Honor.
Yes. But
So that
in
they-
any case,
in
it
that
is-
sense, Your Honor, for the area, they do not
Yes.
compete with any other one, but
for now, while the legislative franchises are not yet terminated or expired, but when it expires, then distribution utilities are actually competing with each other.
I suppose so, Your Honor. If for example, there is a vacuum, Your Honor, in that the old operator that had the franchise expired, and that is open, and I am sure, Your Honor, other franchise
Or that
holders would be
distribution
interested.
utilities will not need to wait until expiration if there is an agreement among them and their consumers that it would be possible to perhaps approach Congress in order to amend the law, Republic Act 9209, I believe, which is your franchise, and include them. Is that not possible?
That's possible, of course. That's
Also, Meralco is unique because you have 70+% of Luzon's demand. Am I accurate in saying that?
For my understanding is around that figure, Your Honor.
Yes. By Luzon, I mean the transmission grid of Luzon. Am I correct?
That's correct, Your Honor.
Both north and south sector.
Yes, Your
Yes.
Honor.
And 62+% of national demand. Is that not correct?
I'm not too sure about the national, but I am certain of the Luzon,
Yes.
Luzon grid, Your Honor.
And this company which you represent, which is large in terms of area and large in terms of the demand that it services, quite a difficult job, I would imagine, purchases electricity from generating companies. Is that not correct?
That's correct, Your Honor.
And to a certain extent, you do have market power. Is that not correct?
In terms of buying power, Your Honor, for electricity, Your Honor, all of these are very competitively priced, Your Honor. So, and as far as I understand, Your Honor, when we are talking of market power, Your Honor, or monopolies, it is either monopoly or oligopolies, Your Honor. I'm not sure whether
And it
monopoly
is,
is covered,
yes.
but however, I understand that even if it is not covered by the definition, still, the other section, Your Honor, of the provision that you quoted, combination in restraint of trade or unfair competition would still be applicable, Your Honor. That's my view.
Market power per se is not illegal. Am I correct to assume that?
That's correct, Your Honor.
Yes.
It's only the abuse of market
Yes.
power.
And market
is-
power, when it is there, could be a reward for efficiency. Is that not correct?
My understanding, it could be what they call business acumen, historical accident, or a superior product, Your
Yes.
Honor.
And
That
it is the duty of the state, this time the ERC, the DOE, and perhaps even this court in the proper case. It is the duty of the state to make sure that there be no abuse of market power. Is that not correct?
That's correct, Your Honor. That's also one of the...
But of course, I may not have been too accurate about it. It is also the duty of the distributing company based on the law, Section 22 and 23 of the EPIRA, that you have to make sure that the consumer gets the least cost. Is that not correct?
That's correct, Your Honor.
Yes. And to a certain extent, therefore, you have to be worried about anti-competitive behavior, which may cause you to pass on very high rates to the consumer. Is this not correct?
That's correct, Your Honor. That's why I direct this honorable court attention to our Annex
In fact, it is
17,
your-
wherein 2006, Meralco complained about the anti-competitive behavior of the three PISAM
Yes.
trading teams at that time, Your Honor.
Of course, we are tempted to talk about that, but there is a pending case here in respect to that specific issue. But in any case, therefore, you would say that because you are big, that you do have an effect in setting the standards in the industry, at least distribution. Is that not correct?
I
Quality
suppose-
standards, work standards, and all of that.
I suppose so, Your Honor, because usually the market leader is always followed, Your Honor. Why is it successful, Your Honor?
And you have great influence also, greater than, by great I mean greater than other distribution utilities insofar as the generation and the transmission sector is concerned. If we compare distribution utilities and their influence on the generating sector, that you do have a greater influence, I would say. Is that not correct?
Well, I guess, Your Honor, it's a matter of degree, Your Honor, but the generation business now, Your Honor, there are 31 generating companies, and Your Honor, Meralco competes with all of these different
Yes, but you have
distribution
70% of Luzon transmission grid, as well as 62% of the national economy. But of course, that is something to be inferred from those specific facts. What is MGen? MGen.
Your Honor,
Is that different from Meralco?
that's MGen, Your Honor, is the local retail electric, is
I
the
think that
local
is-
res, Your Honor, the
No, I think that
retail
is
electric
Empower.
supplier.
I think that's Empower.
That's Empower, Your
Yes,
Honor.
MGen is your generating a subsidiary of Meralco, I assume.
No, as far as I know, Your Honor, Meralco does not have a generating company, Your Honor.
Do you have a subsidiary that will allow you to enter into contracts with generating companies?
Your Honor, I'm not aware. I only know, Your Honor, that the only investment of Meralco on a generating company is the Global Power, Your Honor.
Are you familiar with RP Energy? RP Energy, one of the
I'm
companies,
sorry, Your Honor, I'm
which
not
is a
familiar
joint
with that.
venture of Thermal, MGen, and a Taiwanese company.
You're talking of the Redondo,
Yes.
Redondo Power.
Yes.
Then, Your Honor, if you mentioned Redondo, yes, Your Honor, but that has been, that's non-operational, Your Honor.
Yes.
That's been stopped, Your Honor, by virtue of a...
My question is only
an
what
order,
is
Your Honor.
Meralco's relationship to Redondo?
Redondo, Meralco is a, I'm not sure, Your Honor, what is the extent. I think it's something like 40 some percent, together with Taiwan Cogen and Aboitiz Power, I think, Your Honor.
So Redondo is a company that is setting up a power plant. Is that not correct?
That's correct, Your Honor.
Run on coal. Run on coal. Using coal.
Coal, I understand, Your
Yes, but it has it been completed?
Honor. It has been stopped, Your Honor.
Yes, but in the interest of the investors, they want to complete that. Is that not correct?
That's correct, Your Honor.
So Meralco has a subsidiary that is involved in power generation. Is that not correct?
Well, not yet involved, which intends to get into power generation, Your Honor.
Yes, but actually it has already invested in terms of the capital used to set it up, except that there was a depot.
Yes, I just don't know the details, Your Honor, but Meralco as a DU, they are authorized, Your Honor, to deal with and get supply, Your Honor, up to the extent of 50% of its requirement.
Yes.
From entities.
By law.
Yes, by law, Your Honor.
In the EPIRA.
Yes, Your Honor.
Yes. Therefore, an example of interrelationship of the generating sector and the distribution sector. Is that not correct?
That's what is allowed under the law, Your Honor.
Okay.
That's my
What
understanding.
about Empower?
That
Does Meralco have a supply company
I think it has a
to
local-
participate in retail competition and open access,
Yes, Your Honor.
or ARCOA?
My understanding, Your Honor, is that in December of 2012, the ERC has determined that there was going to be retail competition and open access by middle of 2013, so that customers, Your Honor, that had an average monthly peak demand of 1 megawatt, Your Honor, for the last 12 months, were considered contestable contestable customers, Your
Yes.
Honor. Meaning
me
they
see.
already have a choice to look for their own supply of power.
Let me see if I get it correctly. So Meralco has 70% of the demand of Luzon grid, about 60% of the national demand in electricity. And Meralco is also into, through its subsidiaries, of course, into generation. And Meralco is also into the other sector, which is called supply.
Your Honor, it wants to get into generation and it's not yet there.
Yes.
Okay?
And it
Now,
also
Your-
wants to get to supply. Or is
And
it
in
already
the supply,
there?
Your Honor, under the law, a distribution utility, Your Honor, can set up what they call a local retail supply entity.
Yes,
Your
I
Honor.
am not asking about the legality. I know that it is legal. I'm just wanting to establish something else, which is the facts or the context of this case. So Meralco, therefore, is into all of this. Is that not correct?
To that extent that I understand, because when the retail competition and open access, Your Honor, was initiated, 28% of the load customers of Meralco became contestable customers, Your Honor.
Okay. Among all the power supply agreements that you have with certain companies, is Meralco involved with any of those companies other than as a buyer of their electricity?
None, Your Honor.
No relationship
No
whatsoever?
relationship at all, Your Honor.
Including the relationship of your stockholders, your major stockholders, and the major stockholders of any of the companies that you entered into a PSA with?
As far as I know, Your Honor, we flash on the board, Your Honor, the different companies where we have these power supply agreements as well as the power purchase agreements, Your Honor. As far as I know, Meralco does not have any interest in any of those generation companies, Your Honor.
Yes, just offhand, Counsel, which of those PSAs are your baseload plants and which are your peaking plants?
All the coal plants, Your Honor, if I may be able to show it, all of the coal plants are usually the base plants. The natural gas plants, Your Honor, are what we call the mid-merit plants, and we only have one peaking plant, one peaker. That is the TMO, Your
And
Honor.
TMO's PSA was entered into only lately, and
Yes,
only
Your Honor.
because, according to you, in preparation for the Malampaya shutdown.
That's correct, Your Honor.
Before I proceed with the others, I'm curious. You talked to the generating companies in order to prevent them from shutting down. Is this not correct?
Yes, Your Honor.
My first question is, Meralco was the one that talked to the generating companies. Wasn't it supposed to be Department of Energy that convened all of you?
Your Honor, my understanding it was these generating companies, Your Honor, that made the proposal to Meralco, Your Honor, that during the shutdown of Malampaya that they wanted to run on alternative fuel. And Meralco agreed to that, Your Honor. So it was, as my understanding, Your Honor, this is more of a private effort, Your Honor, more than the government effort, Your Honor.
And I suppose that this is allowed under your PSA,
Yes, Your Honor.
approved by the ERC.
Yes, Your Honor.
Not provisionally, but finally.
For this, yes, Your Honor.
Yes, for these power plants. Because only Therma Mobile, I understand, has been provisionally approved, but all the rest have been already approved.
Yes, Your Honor, because Therma Mobile just came in around September, Your Honor,
Okay.
and it became...
What about the power plants where you ask that they should not shut down during the time that Malampaya would be under maintenance? You did talk to those plants, is that not correct?
Yes, Your Honor, we talked to them to delay their scheduled shutdown, Your Honor.
As a matter of fact, you succeeded in convincing one of them, is this not
Yes,
correct?
Sem Kalaka, Your Honor.
Yes. Why is it that it was not DOE that called them and asked them to delay their shutdown?
I don't know the answer. Only DOE can respond to that, Your Honor, but...
Were you called by DOE to a meeting in relation to the Malampaya shutdown? Preparation for the Malampaya
I've
shutdown?
seen meetings, Your Honor, minutes, or rather, materials, Your Honor, as well as agenda for different meetings, Your Honor. One, I remember, in July, another one in October 10, and another one in November 4 or something around that
Okay.
date, Your Honor.
Now we go to the PSAs. First, maybe just to establish things, what is Meralco's average total demand? Ballpark figure.
For the average or peak demand, Your Honor?
No, average total demand. Okay, maybe. What is Meralco's contracted capacity?
The contracted capacity, Your Honor, right now is 5,070 something, Your Honor, megawatts.
And the total demand that you need to fill out
The
is?
total demand, Your Honor, these are the figures that I know, Your Honor. If it is on the average peak demand, Your Honor, it's about, we are about 130 some figure, Your Honor, above the average peak demand. And for, average demand, Your Honor. But for peak demand, the supply contracts we have are about 90%, Your Honor.
Why not contract 100%?
Your Honor, the analysis is that it is going to be more expensive if you contract 100%, Your Honor. And here, the assumption, Your Honor, of course, is that you assume that the prices at WSM are reasonable. Your Honor, if you will look at a curve, Your Honor, when you contract full 100%, Your Honor, you will have to cover the full amount, Your Honor.
Yes.
And usually, Meralco contracts at about the current policy they have is at least 90%, over 90% coverage, and up to 10% from the USM.
Yes.
The portions, Your Honor, not covered by the PIC, where you have to pay capacity fees as well as fixed O&M fees, comparing that, Your Honor, to the PIC that you buy on the assumption, Your Honor, absent this aberrant spike in the USM prices, the computation of Meralco, Your Honor, and their exercise of business judgment, it is better to just buy in the USM, Your Honor, up to 10% of your capacity, Your Honor,
Yes.
or you need.
The next questions I would not have asked had you been able to make your presentation that you submitted to us, but I need to ask them in order to lay the predicate for some of my other questions.
Yes, Your Honor.
So there is a peak and off-peak in terms of the load.
That's correct, Your
Yes,
Honor.
and peak is what hours?
For,
More or less. Of course, it
is-
differs commercial, industrial, residential, but generally,
Generally, Your Honor, our peak is considered as 9 a.m. to 9 p.m. at night, Your Honor.
okay, and off-peak is the rest of
The
the,
rest of that, Your Honor.
okay. What about Sunday? Is it off-peak?
Insofar as our contract with TMO, Your Honor, Saturday and Sunday are considered off-peak, Your Honor. But of course, in any day, there will always be peaks and non-peaks, Your Honor, or peak, the low, the shoulder, the peak, the shoulder, and then the trough, Your Honor.
Yes.
So for every day, there is, it's, as I mentioned, Your Honor, it is volatile per day, per week, per month, and even during the year, Your Honor.
Yes, okay. Maybe we should not show this slide. This is yours.
Yes, Your Honor.
Yes, and people might say that I had a contribution to this slide. Mine is
no.
really independent questions. So in any case, there is peak and off-peak, and I am curious, what is your generation protocol in terms of your PSAs? Which one do you dispatch first, and which one do you dispatch last?
Your Honor,
During peak and off-peak, maybe just a general discussion of this.
my understanding, Your Honor, is almost all of the base load plants, Your Honor, are discharged for 24/7, Your Honor. For the mid-merit, Your Honor, again, it will depend on what is the need, Your Honor, and they can also be ramped up at certain periods of time. And TMO is strictly a peaking plant, Your Honor.
Okay. And so therefore, my understanding is, in terms of volume and price, you engage first or dispatch first the base loading plants, and only at the peak do you engage the peaking plants.
That's correct, Your Honor.
And why is this the case?
Because, Your Honor, the peaking plant, Your Honor, is expensive, and you will only use it when there is that demand, Your Honor.
Okay.
Because,
Looking at the contract with TMO, I just abbreviated, Thermamobile, there is a maximum utilization factor of 40% in the contract. Can you explain to us what that means? Because it will be relevant later when we take a look at the relationship of Meralco and TMO. So
the
first,
PCF, Your Honor, is what they call the load factor. This is the like a plant, Your Honor, where the plant contract, where you're using it, Your Honor, like a base plant, Your Honor, the plant capacity factor is.
No, I'm talking about maximum utilization.
Your Honor,
factor.
I'm just trying to illustrate. It's the number of or percentage of the time that you're using it. So if you say 40% plant capacity factor, you're using it only 40% of the time or the hours that it is available.
And in your contract with TMO, we noticed that in terms of allowable shutdown, the number there was 0. What does this mean for TMO?
I'm
0
not
days
sure.
shutdown until December, I think, 25, 2013.
Because, Your Honor, that was negotiated because it precisely to address the Malampaya shutdown, Your Honor. It was needed during that period of time, Your Honor.
So you engage TMO in order to prevent a spike in prices during the Malampaya shutdown.
That's correct, Your Honor.
But in effect, what happened was there was a spike in the prices
That's correct, Your
in
Honor.
spite of your engagement of TMO.
Because the problem, Your Honor, was there was several plants violated the WSM rules, Your Honor.
Okay, we'll get to
Some
that.
offered and did not run. Some offered but did not offer their full maximum capacity. And some went on forced outages, Your Honor.
Yes, those are very serious allegations. We will ask you to name names later, perhaps. But in any case, for now, you are paying. What is the contracted price with TMO?
The indicative price, Your Honor, as I understand it, is 11.26 centavos. But the actual for the November supply month was around 8.26, if I'm not, or 8 something, Your Honor. And for the December supply month, it was 10.40 something, Your Honor.
Okay. Why is it if the price in the spot market clears at 62, and there is some capacity of TMO that clears in the spot market? Okay, you nominated and it was offered and it cleared. TMO cleared at 62. Do you pay TMO 62 per kilowatt hours, or do you pay the contracted price?
The contracted price, Your Honor. Especially so, in the WSM, Your Honor, the bilateral contract quantities, Your Honor, are netted out. Only the excess is settled under the WSM prices, the market clearing prices, Your Honor.
Yes.
So a fully contracted plant, Your Honor, will always be settled under the bilateral agreement that they have, Your Honor.
So between
and
you and TMO, the price will be the same regardless of what clears in the spot market, provided that the supply comes from TMO
That's correct, Your Honor.
and within the contracted capacity of TMO.
That's correct, Your Honor.
Yes.
It's
However,
always,
for those that participated in the market, if TMO was the clearing plant, the marginal plant, then the price for them would not be the contracted price with Meralco. That's logical, is it not?
Your Honor, it depends again whether those other,
Bought from the spot market.
whether they have bilateral contracts or whether they are buying on spot, Your Honor.
Maybe
the
to be-
spot is, of course, going to be settled under the WSM clearing price, but their bilateral quantities will be settled under the bilateral agreements that they have.
Maybe to be clear about the questions, and perhaps just to lay the predicate also for the questions of my other colleagues, if you wouldn't mind, I will present a variation of what was in your slide, just to be clear about marginal
Yes,
plant
Your
clearing
Honor.
price. So this is slide 51, the gross pool slide, which I borrowed from one of the amicus from the School of Economics. So let us assume that there is a demand. Of course, the demand is not set by the distribution utility. Is this not correct, Counsel?
Well, Your Honor, it is not set in the sense that it is the customers, but of course the distribution utility through time, Your Honor, comes out with a forecast.
Yes. But you are given a power situation outlook by a government agency or by the NGCP?
The NGCP, Your Honor, publishes what they call the power situation outlook on a daily basis, Your Honor.
Okay. And that power situation outlook is based on the offers that the NGCP that are made at the WSM. Is this not correct?
I am not sure what...
Okay, but we will ask that of the NGCP when they make the presentation. Let us assume that the needed demand is 400 megawatts.
Yes, Your Honor.
Okay, next, that there are 4 generating plants, which we will call G1, G2, G3, and G4.
Yes, Your Honor.
The first number in the parenthesis is the available capacity. So 300
Yes.
megawatts, 250 megawatts, 60 megawatts, and 100 megawatts. Okay, and that the prices are 5 pesos, 1.5, 2 pesos, and 1 peso.
That's right, Your
Okay. Just as an illustrative example, just so we get a basis for our next set of questioning, we are correct in saying that the first plant to be dispatched by the computers of WESM would be G4. Is that not correct?
Under the so-called
Merit order.
the merit order of
Yes.
dispatch, Your Honor.
Yes. The
Yes,
lowest.
that's correct.
The lowest.
It is arranged
offer.
from the lowest to the highest, Your
Okay.
Honor.
So first, of the 400, 100 is supplied by G4. Then thereafter, the next set will be supplied by G2. 250 is supplied by G2. But still, there is a missing part of the demand. Therefore, it will be G3 that will actually
That's correct.
occupy the last portion. But G3 will not provide all its available capacity, only a portion that is needed. And of course, the last plant, which is G1, will not be dispatched, or it will not be connected to the grid. Is this not?
That's correct, Your Honor.
Yes. The clearing price in the spot market is not each of the prices that have been bid by each of the generating companies, but rather it is the price of the last plant that completed the demand, also called as the marginal plant. Is this not correct?
That's correct, Your Honor. That
Yes.
is how the WESM price determination methodology works, Your Honor.
So it will be at 2.0.
It will be, yes, Your Honor. That's correct.
And this is the practice that has been done in the WESM for a long time. Is this not correct?
My understanding since it's started operation in 2006, Your Honor.
Yes. But of course, to an ordinary layperson who first encounters this merit order, asks themselves, why is it that the price to be paid is the highest price that is offered in the market rather than the lowest? Would you have an explanation, counsel? Only if you have.
No, Your Honor. In fact, our comment, Your Honor, is that it should be pay as bid, meaning you pay G4 only 1, you pay G2 only 1.5, and you pay G3 for that at 2, Your Honor, instead of paying all of them at 2.
Okay.
That is, in fact, the position of Meralco, Your Honor.
Yes, just to clarify a few more other things. The price at which a plant offers is not exactly their variable cost, plus fixed cost, depreciation, whatever, correct?
Your Honor, it's not the way it's working in the market. It's not that way, Your Honor. Ideally, it would be. Because if you look at the bids, Your Honor, there are some who bid at 0, just to ensure that they are dispatched.
So just point by point. First, that each of the generating companies do not actually bid only their cost plus a fixed margin.
Yes, Your Honor.
It depends on their interpretation of the market, and therefore, at a certain sense, they determine whether or not they want to be dispatched, or for some other reason, they will bid a particular number. Is this not correct?
I would say, Your Honor, for those that had bilateral contracts,
Let's go by it step by step so that we can go to the point that you're
Okay.
about to make right now. So just a question. For each generating company that has a trader in the spot market, they will they will offer a price which is not necessarily equivalent to their costs, but it will have variable margins or variable profit depending on what they want to do in the market, whether they want to be dispatched or not dispatched.
Your Honor, let me...
Just yes or no.
I cannot answer that with a simple yes or no, Your Honor. Because for those who would want to trade in the spot market, I take it, Your Honor, that they will trade whatever the price is, could be, they will of course want to cover their variable costs.
Of course.
It could also be that they will have already some profit
Higher,
there.
yes. And it's possible to bid at 0
Yes,
in
Your
the
Honor.
spot
But
market.
for...
And the company that bids at 0 does that for a motive.
Yes, Your Honor.
What
those,
is that motive?
Usually, those are the plants that have bilateral contracts.
And
if they are base load, especially the base load GenCos, Your Honor, sometimes they even bid at minus
Yes, negative,
that amount.
because
So that-
they want to be dispatched at the lowest point. Is this not
yes,
correct? Yes.
because of that
And if a
objective,
plant
Your
does
Honor.
not want to be dispatched, or that there is a capacity for the plant that they do not want to dispatch, Therefore, they bid the highest price in order that they are last in the merit order. Is this not correct?
That is exactly what TMO did and Meralco did, Your Honor, for the off-peak hours.
But let us not jump to that. Just to clarify the basics, just so our questions will have the right predicate, and so that everybody understands, including myself. Just clarifying from you, correct? There is a ceiling price in the WESM, correct?
There is a ceiling cap,
And
Your
that
Honor.
ceiling cap is 62.
62 before, Your Honor, but now I think they reduced it to 32.
In November, we are not concerned about what happened right now, at least for at this point of interpellation. At that point, it was 62.
That's correct, Your Honor.
What is the economic reason why it is 62? Would you know, counsel?
I don't really know, Your Honor, but I can only expect that is...
Would you know if there is any, in your experience, would you know if there is any generating company whose costs are 62 pesos per kilowatt hour?
Your Honor, I've looked at the different costing, and this costing of 62 are quite high, Your Honor. They are not.
In fact, theoretically, in a spot market, there should be no ceiling price. In other words, because it is fair competition, it can go as high as 1,000 if the plant does not really want to bid. Is that not correct?
That's true, Your Honor. In a free competition, Your Honor.
So at some point, somebody has to explain why it is 62. Is that not correct?
I guess, Your Honor,
because it is arbitrary and looks arbitrary and capricious. Is that not correct?
The best persons or entity to explain that, Your Honor, is the DOE, ERC, and PEMC, Your Honor, because they were the ones who had that tripartite agreement to set the bidding cap, Your Honor.
Okay. You do admit that in terms of your power supply agreement partners, that there are clauses there, uniform among the PSAs, where it allows Meralco to nominate or to tell them what the offer should be in the spot market. Is this not correct?
That's correct, because if they are fully, especially, Your Honor, if they are for the volumes that they are contracted, Meralco, of course, will dictate when they want the power to be dispatched, Your Honor, as when they need it.
Why?
Because, Your Honor, you don't dispatch a peaking plant on off-peak hours. You want a peaking plant to be dispatched at the peak hours.
Why wouldn't you want that plant to be operating at all hours at its cost, and depends on the market whether it will be dispatched or not?
It's going to be very expensive, Your Honor. My understanding, Your Honor, that for most of the day, Your Honor, where the demand, Your Honor, is stable, let's say, you dispatch your so-called base plants and your mid-merit plants. And it is only during the peak hours where you dispatch your peakers or your peaking plants, and you conserve their energy and their contribution to the demand at the peak hours, because usually the peaker plants, Your Honor, are more expensive plants.
Okay. Can we go to the next slide? The market cleared at 62 many times before you engaged TMO as a PSA, Power Supply Agreement Partner. Is this not correct?
That's correct, Your Honor.
Yes, and there were again many times after TMO started commercial operations that the market cleared at 62.
That's correct, Your Honor.
So why is it that you still continued to bid at 62 rather than another price, so that the market's price will not be increased too much to 62?
Your Honor, the strategy is still the same, Your Honor. One, all the power outlook that we were provided with, Your Honor, all indicated that there was ample supply. Okay? And also, Your Honor, we expected and we relied on that data being given to us, Your Honor. Second, we expected that all participants in the WESM, Your Honor, should comply with the rules, that if they bid, they should run, or if they should be dispatched, and dispatched at the maximum capacity that they have.
Okay, maybe I'll show you another slide, slide 54. The clearing prices for November 2013, it cleared 5 times at the price ceiling of 62. cleared at 60 for 22 times and 45 for 43. 45 is a number of the highest variable bid other than 62 and 0. So here, this should have been apparent to your traders. Is that not correct?
Yes, Your Honor. The Meralco has an energy source department that monitors.
Yet in spite of that, Meralco did not bid at 46 or 50. For TMO, it told TMO to bid at 62. Is this not correct?
Your Honor, precisely the strategy of Meralco, Your Honor, because of the plant capacity factor, precisely, Your Honor, was to conserve that particular plant, Your Honor, for its peak requirements. And two, Your Honor, for all of these days, Your Honor, the supply forecast, Your Honor, that was being given, that there was adequate supply. There was only one time, Your Honor, and this came out, Your Honor, in the Senate hearing, that it was only on November 15 that NGCP issued a yellow alert, and it was from 11 to 7 p.m.
Yes, we'll get into that.
For only one day, Your Honor.
We'll get into that later. But the point is that having seen the behavior of the market in real time, your traders still continue to bid at 62. Is this not correct?
Your Honor, the traders, once you see a certain price, Your Honor, even if you wanted to react, you will need at least 2 hours, Your Honor,
yes,
before you're able to change your bid.
But there's
and to implement the bid, Your Honor,
ahead, and there is
it's
month
another
ahead.
hour, Your Honor.
Yes, so you would see the prior days also, and you would also see the prior hours, in fact, and it would be possible for you to react 2 hours before. As you said, is that not correct?
But here, Your Honor, these are all forecasts, and no one can predict, Your Honor, that there will be certain plants.
But you admit that it was Meralco that nominated the offer, that told the TMO to bid at a particular amount.
Your Honor, the strategy of Meralco is simple, Your Honor.
Now, the question was, you would admit that it was Meralco that instructed TMO to bid at 62.
Yes, because
Yes.
it was fully contracted,
Maybe
Your
let's
Honor,
look
and
at
the
the
strategy
next
is simple,
slide.
Your Honor. For off-peak, it was going to bid at 62.
Yes, we get
For
the strategy.
peak, it was going to bid at 6 or 8, Your Honor,
Yes.
the variable cost,
We get
so
the
that it will
strategy.
be dispatched on peak
Yes,
and not dispatched on off-peak hours.
we get the strategy. Maybe let's look at the next slide, slide 55. This is from all the submissions that have been given to us. And you would see the market clearing price at the darkest color is 62, then it goes lighter and lighter. If you will see, so we will just scroll through it very quickly. It was Limay, TMO, and next slide, and Bawang that actually cleared the price many times in November. By the way, Council, is there a relation between Bawang Power Plant and Meralco?
None, Your Honor.
Not even with Empower?
I don't think so, Your Honor. I think, as far as I understand, there's no relationship, Your Honor.
Okay, we go now to the clearing prices for December of 2013. It cleared 54 times at 62, and then at 60 it cleared for 59 times, 45 kilowatt hours, pesos per kilowatt hour, 68 times. Yet Meralco continued to offer or ask TMO to offer 62. Is this not correct?
That was still the strategy that it had, Your Honor. May I just quickly add, Your Honor, that Meralco and TMO, Your Honor, did not benefit from any price at 62,
yes, we got
Your
that.
Honor.
But Meralco, of course, gave instructions to TMO. The market price was 62, and for all the others that bought from the spot market, including Meralco, the 10% that you had to buy, you had to take the price that was set in the market. Is that not correct?
That's correct, Your Honor. But may I just say, add, Your Honor, that there is nothing wrong in bidding at 62.
Yes, nothing wrong per se.
Your Honor, that was statement made by the
Senator
market
Osmeña.
operator and
Yes.
Senator Osmeña, Your
Yes,
Honor.
who is not a justice of the Supreme Court.
Yes, Your Honor.
Yes.
But he was
Nothing wrong
but
with
he was the
bidding.
principal author of EPIRA Law,
Yes.
Your Honor.
There is nothing wrong with bidding at 62. I would agree with that, but that's not my question. My question is, in spite of this market behavior, still 62 was the consistent bid of Meralco.
Because, Your Honor, that
By the
is
way, do you have the obligation to look for the least cost?
Your Honor, yes, we did, Your Honor. Precisely, that is our obligation, Your Honor. And precisely what we are saying is that we did not want to use the plant capacity factor for the TMO for off-peak hours, Your Honor.
Yes.
We wanted to use TMO for peak.
Can we
Your
go
Honor,
to the
the
next
problem,
slide?
if I may be allowed, Your Honor, the problem precisely, I understand, Your Honor, is the so-called must-offer rule of the WSM. Even if you are fully contracted, you are asked to bid. And, Your Honor, if you are fully contracted and you do not have any excess to offer to the WSM, why should you be allowed to bid or even participate?
Your point is fully well taken, but let me just proceed in order just to clarify a few more points. This is the behavior in December. In December, it cleared 62 many more times because of the, for many reasons. Next slide, next slide, next slide. Okay, this is a summary which we got from the submissions of PEMC, the RTD reports. And if you look here, for instance, in December 8, 2013, TMO offered at 62 upon instructions of Meralco, and only 0.5 megawatts was dispatched. 12/8/2013, 22, that is the interval, that is 10 o'clock in the evening, I presume. The TMO offered 62, and what was dispatched was 0.5 megawatts. So the market cleared with the offer of Meralco at 0.5 megawatts. Is there something wrong with this, Counsel?
Your Honor, precisely in one of our slides and what we would want to present, during certain period of time, Your Honor, there were certain plants that were already running. And yet, they made an offer, one I remember, Your Honor, they made an offer of 260 megawatts. And they were only made to run, I think, about 114, Your Honor. Now, it was so easy for them to have that plant, which was already running, to ramp it up to 260.
Yes.
And yet, TMO, which was just on standby, Your Honor, was made to run, and precisely, Your Honor, for only 0.5 of a megawatt, Your Honor.
Yes.
And in fact, what we ourselves are asking, was TMO made to run just to hit the 62? Because there were other capacities, Your Honor, that could have been asked to run.
That is a good question, Counsel. Also a question that we have been asking ourselves, and also a question that we have been asking why ERC was unable to see all of this immediately when they were given, they being the experts in the power industry and we only being Supreme Court justices and just looking at these figures only now. But in any case, again, proceeding with the example, next slide, I think this is what you mean, that there are certain days where TMO hit at 62, and there were other plants, let us say Malaya, which bid at 45. Yet, in the merit order, it was TMO which was allowed to dispatch, not Malaya, who actually made a bid of 45.
That's correct, Your Honor. That's precisely our question.
Is it Meralco's design that TMO operate and Malaya not operate?
Your Honor, as I was saying, it is to our interest not to dispatch TMO because precisely we're reserving TMO for our peak requirements.
So how do you explain this,
plants
Counsel?
already running.
That there was a must-offer rule, which means that if you offer and you are dispatched, then you must dispatch.
That's right.
But there are instances where there is a bid price lower than TMO, yet these are not made to dispatch. It is zero.
That's precisely the
Yes.
same question we're asking, Your Honor.
Yes. But on the other hand, looking at Meralco and TMO, that you could have bid lower than 62 because you had the responsibility for least cost. You could have bid 50 and the price wouldn't have hit 62. Examining the market behavior in the past, that it already breached or reached the ceiling several times. Would you not agree with me, Counsel?
Your Honor, as I said, the business judgment of Meralco and the strategy, Your Honor, precisely to lower its cost to its customer, was to get a peaking plant and make that peaking plant with a capacity factor, Your Honor, plant capacity factor of 40. You would want it to run only at peak, Your Honor.
Okay.
Because the moment you exhaust that right away, then you have to get supply from the WESM again, Your Honor,
Yes.
where the prices are volatile at this particular time. But the question, I think, Your Honor, that needs to be asked is, what is the proximate cost? Why?
Well, that is for torts, and it will depend on the court as to what the questions will be asked in this particular situation. Okay, maybe last few questions. A monopoly is defined in the textbooks of economics, which we all had, Economic 11 or the Basic Economics, as the ability to be able to control the quantity, okay, restrict the quantity, and because of the restriction in quantity, the price would increase. Anyone with that ability is a monopoly. Is that not correct? Anybody with the ability to restrict quantity and therefore affect price, okay, would have a monopolistic position in the market. Would you agree with me?
Your Honor, the essence of monopoly is correct, that,
Yes.
that it is to
So here
influence
you have
the price.
Meralco and TMO agreeing not to dispatch 100 megawatts by bidding 62. And Meralco and TMO succeeding in actually clearing the price at 62. Counsel, is this not a combination in restraint of trade?
No, Your Honor.
Why?
Well, one, Your Honor, the parties are allowed to bid at that price. The strategy, Your Honor, they have a justifiable reason for doing what they did, Your Honor, which is to bid high during off-peak so that they are not dispatched, and to bid low or at variable cost when at peak when they want to be dispatched.
Yes.
So there is a business reason. They, and I want to stress this, Your Honor, for all of the monopolistic activities, Your Honor, profit motive is number one. They all wanted to influence the price because they want to make money. Here, TMO and Meralco did not make money, Your Honor. Meralco is prohibited from making money for pass-through charges. So it cannot be a violation or combination in restraint of trade when the profit motive is absent, Your Honor.
There is a cross-ownership provision in the EPIRA. Is this not correct?
That is correct, Your Honor, with respect to...
Meralco cannot own so much in terms of the equity or the ownership of a generating company. Is this not correct?
My recollection, Your Honor,
30%.
is that... Yes, Your Honor.
Yes. Why is there such a provision?
The provision, I understand, Your Honor, is so that precisely they
will not collude.
is
The
for that
distributing
reason.
utility and the generating company will not collude or come into a tacit or express agreement relating to the price. Is this not correct?
That is the rational, I would think, so, Your
This
Honor.
practice of the distribution utility able to tell the generating company the price to be set, does this not indirectly violate that provision?
No, Your Honor, because
Why?
precisely, Your Honor, the bidding, Your Honor, you have to understand the difference between the WESM market and a stock market, Your Honor. In the WESM, Your Honor, the buyers of power only quote the quantity. They don't even know the price. The price will be determined later. Whereas the suppliers, Your Honor, or the offerers, or those who ask, submit only, Your Honor, the quantity as well as the minimum price.
I understand this, counsel, but my question has something to do with the law. And the law says that there cannot be such a relationship with the generating company and the distribution utility such that the distribution utility can control the generating company. That's why it's set at 30%.
Your Honor,
Therefore, my question, counsel, if that is the case, that's the spirit of that provision, therefore, wouldn't it be logical to say that this practice of the distribution utility actually controlling the behavior of the generating company in the market goes against the spirit of that provision.
Because of the must offer rule, Your Honor. If there is no must offer rule, then Meralco and TMO will
I'm
not
sorry.
even participate.
The must offer rule is for the generating companies that are participating in the market.
Whether
But in your contracts, there is an agreement that Meralco will nominate.
that's correct, Your Honor.
Yes, but the must offer rule in the WESM, of course, may have its own pros and cons. But we are talking about, again, this particular question.
Your
Perhaps
Honor,
you can cover it in your memorandum, unless you want to explain it now.
I just want to make this point, Your Honor. If there is no must offer rule, Your Honor, and it is not a gross pool, but only a net pool of what the generating companies can sell, then that problem will never arise, Your Honor. But because of the gross pool and the must offer rule, then the GENCO has no choice but to make an offer, even if it doesn't want to be dispatched. That is the root of the problem, Your Honor. You take that away, then there is no reason for Meralco and TMO
Yes.
to be participating in the WESM and setting a price at 62.
A point that you clearly made. My very, very last question. Okay? You have identified so many things wrong. Gross pool, marginal clearing price instead of pay as bid, that a plant did not actually operate. Therefore, it spiked to 9. Okay. You have identified that. Why is it that the ERC did not even care to look at this extraordinary jump in prices? Wouldn't you think that there is grave abuse of discretion on the part of ERC?
Your Honor, it pertains to the staggering of the collection, Your Honor, there is absolutely none. As to their action, Your Honor, with respect to this, I will rather not comment. All I would want to say, Your Honor, is that during one of the meetings, Your Honor, Meralco suggested that the WESM administered price should be used for the duration of the Malampaya shutdown, Your Honor, and
Yes.
that is on record.
That's another point altogether, which I already asked from, I think, the petitioners, the concept of the administrative price. But still and all, perhaps you can cull from some of the questions, and I would be very interested that in the memoranda you cover some of them. And thank you for your time, Counsel.
Thank you, Your Honor.
Counsel, I have some questions.
Yes, Your Honor.
Meralco contracted the entire capacity of Thermomobile.
That's
Is that
right, Your
correct?
Honor.
That's about 343 megawatts,
Uh,
or whatever can be produced by Thermomobile.
Initially 100 and going up to 240 something.
Okay, but the
2%.
entire capacity.
The entire capacity, Your Honor.
Now, therefore, Thermomobile could no longer sell that at WESM without the consent of Meralco, correct?
Yes, Your Honor.
Now, Meralco instructed Thermomobile to sell at 62, correct?
Not to sell, Your Honor, but because of the must bid
Yes, I know. So to offer to sell
to
at 62.
offer, Your Honor.
Yeah. With the intention that it will not clear, nobody will buy it.
That's
Because nobody would dare buy at 62, correct?
that's correct, Your Honor.
Okay, because at 62, you still have to pay the VAT and the fee of WESM. You'll be paying more than 62, and you cannot resell it higher than 62 at WESM, correct?
That's correct, Your Honor.
Okay. How many times did Meralco buy what it ordered to sell at the WESM? Meralco instructed Thermomobile offer at 62, and Meralco, I think, bought at 62 also, correct?
The price, Your Honor, is at the contracted price, not at 62.
No,
Your
no.
Honor.
My question is, did Meralco buy at 62 at WESM?
Your Honor, it withdrew power at WESM at 62, but the settlement for bilateral quantities, Your Honor,
We'll go into that. My question is, Meralco told Thermomobile, sell for me at 62, offer at 62, correct? And Meralco also bought at 62, correct?
that's not quite accurate, Your Honor.
No, but that...
That's not quite accurate, Your Honor. The WESM is not like a stock market, Your Honor, where you ask a certain bid and another
I
person
know.
makes an ask.
I know, whatever was the price agreed upon at WSM, Meralco will still pay the bilateral contract price, correct?
That's correct.
But when Thermomobile offered at 62, somebody bought, correct? Several times. Somebody bought.
Yes,
because it cleared.
Yes, yes, Your Honor. That
Did
is the clearing
Meralco
price.
buy at 62?
It bought, it
At
withdrew
62.
power at 62.
It bought. It bought at 62.
Yes, Your Honor. But
Now,
settled, no, bought in the terms, Your Honor,
Yes,
of
I know.
withdrawing, but paying.
Okay.
Thermomobile
Okay, we
and
understand
it's
each other now.
Yes.
Meralco told Thermomobile, sell for me at 62. Meralco also bought at 62, but Meralco paid only the bilateral contract price of 865, correct?
That's correct. That's correct,
So
Your Honor.
at the WSM spot market, you have a situation where the seller and the buyer are one and the same, correct? Because Meralco told Thermomobile, sell my capacity at 62, and Meralco bought it also at 62, correct?
Your Honor, by the time Thermomobile made an offer at the WSM, Your Honor,
At 62.
at 62, it already sold all of its capacity to Meralco.
Yeah, I know
Your
that.
Honor.
We all know that. But we are looking at the transaction at WSM now. There was a seller. There was a party, Genco, that offered to sell at 62. That was Thermomobile, correct?
The price.
And
that
there
they
was a
could-
buyer. And who was the buyer? Meralco, correct?
There are also, yes, Your Honor, because when you withdraw
Yes,
power, you're
Meralco
effectively a buyer.
therefore instructed Thermomobile sell at 62 and Meralco bought at 62, correct?
That's correct.
But
Hoping
Meral-
that it will not be dispatched, Your Honor. If you will, please.
Yeah, I don't know. I'm not yet asking whether it's dispatch or not. But you have here a clearing price at 62, correct?
That's the
Established by one party, Meralco, because Meralco is the seller and the buyer at the same time, correct?
the price established, Your Honor.
Yes, that's the
under
clearing
the
price.
determination mechanism that it is the highest marginal price.
yeah. But of course, Meralco only paid Thermomobile at 865, the bilateral contract price,
Yes,
correct?
that's correct, Your Honor.
But that
for
clearing
November.
price of 62 affected the other transactions during the trading interval, correct?
That is the design of the WSM, Your Honor.
Yes, your
That is
answer
the
is yes.
design of the
The
WSM.
62 applied to all other transactions below 62 within the trading band of 1 hour, correct?
I agree, Your Honor. That's
So,
precisely
okay.
what we're
My-
saying, that is one of the rules that we
Yeah,
believe, Your
I
Honor,
know.
should be
Okay.
changed.
Now, the EPIRA law says what will be transferred to the consumer is the actual cost of the electricity, correct? Actual cost.
The
You are
pass-through
saying
cost.
pass-through cost is the actual cost. Okay.
Your Honor.
But in this case where the clearing price was 62, and there were other transactions below 62, 5, 10, 15, the actual cost to the consumer should be the weighted average price, correct?
It's not the market, Your Honor, does not
No,
work
I mean,
that way.
forget about the WSM rule yet. I'm asking about what is the requirement of the law. You can pass on only the actual cost, correct?
Right now, that is the actual cost,
Yes.
Your Honor.
No, the actual cost is the original price determined by the buyer and seller below 62. The 62 is the regulated cost. That is not the actual arm's length cost. Because the actual arm's length cost may be 5, 10, 15, and 62 is the clearing price. And the clearing price applies to all the other transactions, correct?
Only for the spot
For
purchases.
the trading hour.
For the purchase price
Yes, I know.
of the WSM, Your Honor. But
Yes.
the bilateral quantities.
Yes,
the-
I know. So
are
we're talking
settled
here
separately.
only of about not more than 10%, correct? Of the total capacity. Because the WSM only supplies about what, 6 to 10%?
On the average, Your Honor, before the aberrant month of November and December, it was about 6 to 7%.
Okay, about 6 to 7%. So we're talking here of the effect of the clearing price on the 6 to 7% to the consumer, correct?
Yes, Your Honor.
Okay. Now, the EPIRA law says the distributor DU, the distributor utility, must only pass on the actual cost, correct? And
It says-
ERC is mandated to see to it that only the actual cost of the GenCo will be passed on to the consumer, correct?
That's correct, Your
Okay,
Honor.
do you agree with me that the clearing price is not the actual cost? That is the regulated cost, correct?
Your Honor, you're talking of two costs, Your Honor. One is the billing of the generator to Meralco, like for example, TMO, Your Honor, for their quantities.
No, I'm not
It is-
talking about the bilateral supply now. I'm talking
is-
about that 6 to 7%.
Your Honor, I'm trying to explain that there are two bills that will be received, Your Honor. One is a bill directly from the GenCo for the so-called bilateral quantities.
At bilateral
The-
price.
Yes, Your Honor. And there will be a WESM bill. This is the bill coming from the WESM.
Yes.
Billing the trading participant. That is the WESM bill, Your Honor.
Okay. In the WESM bill, the price will be the clearing transaction price at 62, correct?
That's
Even
correct.
if there were transactions below 62, correct?
That's correct. It's not, as we mentioned, it is not pay the bid, Your Honor, but it is the highest marginal
Yes.
clearing price
But
that is applied.
that kind of rule doesn't transfer to the consumer the actual cost, correct?
Your Honor, if you will look at the WESM and the EPIRA, that is what the WESM determines through the price determination methodology that they have.
Yes,
That
my
is the
question
cost.
is,
That
does-
is the cost.
No, my question is, does that follow the law? The law says only the actual cost of the electricity will be charged to the consumer.
It says least cost, Your Honor.
Yeah, for that trading band, what is the actual least cost?
Your Honor, for that, Your Honor, the concept of the WESM, it's supposed to work in such a way that it will optimize the price, Your Honor. But
Okay,
because
let's go
I
to
think
another subject.
I think the question that should be asked, Your Honor, is why did it ever hit 62, Your Honor?
Okay,
What
that's
is
my
the
question now
approximate
to
cost?
you. Why did Meralco buy at 62?
Your Honor, a DU, Your Honor, you do not have a choice. You just make your demand, Your Honor, as a buyer of power. You just say what is the quantity that you want. You do not state the price, Your Honor. The price will be dictated to you. You are just a price taker.
You mean to say when Thermomobile offers at 62, that's it? That's the price already? The Meralco cannot reject that price?
Your Honor, if you're buying on spot, let's say, Your Honor, let's not take TMO. Let's say Meralco wants to get from the spot market. Whatever is the price that is set by the price determination methodology of the WESM, you are just a price taker. Whatever that is, you take it.
Who determines the price? WESM or the market?
It's supposed to be the market, Your
And
Honor.
the market is composed of the buyer and the seller, correct?
But it is, Your Honor, the price will be determined by the highest
Yes,
marginal
and
price.
the last marginal price is 62, with one seller, Meralco, and one buyer, Meralco, correct?
No, Your Honor, you will have to understand that the WESM, all of the distribution companies, all of the companies
Okay.
are making their bids to buy, Your Honor, as
Okay.
well as all of the generators. In fact, you do not know where the power that you are withdrawing, you do not know where it's coming
I
from.
understand that, Counsel. Now, answer me. How many times did Meralco buy at 62?
Your Honor, I would rather say that how many times did the price of 62 cleared, and how many
No,
times?
when Meralco has to decide for itself whether to get that at 62 or not, correct?
Your Honor, a DU that is buying power from the WESM, Your Honor, is just a price taker.
You mean to say the price in WESM is not determined by the buyer and seller?
It is determined, Your Honor, on the last
Yes. So Meralco bought last 62, correct?
From the WSM, Your Honor.
Yes, from the WSM.
From the WSM.
So how many times did Meralco do
That's,
that?
as far as we know, Your Honor, from the records, from 50, I think TMO hit 62 25 times, Your Honor.
And how many times did Meralco buy at 62?
That for
25 times.
yes, Your Honor, from TMO.
So,
But
in
the
other
settlement
words-
is still under the bilateral contract.
Yes, but okay, it paid under the bilateral contract, but it told Thermomobile, sell for me at 62, and Meralco bought also at 62, correct?
No, it's not. Your Honor, it's not telling TMO to sell at 62. It is made, Your Honor, you
Now,
for the merit order of dispatch, you place yourself at 62
okay,
so that you will not be called.
you said before that Meralco told the Thermomobile, I don't want it to be dispatched now because it is off-peak.
That's
so
right.
you offer it at 62 so that nobody will buy, correct?
That's correct, Your Honor.
But Meralco bought at 62, correct?
Because at that point in time, Your Honor, when the market clears and you have withdrawn power from the system, then whatever the price that is set, you take it. Whatever is the price that is set.
So in
the
other words,
market,
Meralco bought without knowing how much it will pay. That is what you're saying.
Yes, Your Honor. From the very beginning, every time a buyer of power, Your Honor, goes to the WSM, you do not know what is the price that you will get. You will only know after the trading hours and a few days
WSM
after.
is structured in such a way that the buyer buys without knowing how much he will pay. That's what you're saying.
That's correct, Your Honor. It is, the buyer is a price taker.
So Meralco said, okay, offer at 62. And Meralco also bought knowing that there is an offer at 62, correct?
Your Honor, Meralco does not even know what it will be the clearing price. The clearing price will only be known to it after so many hours, Your Honor. It's after the trading. I don't know how many days.
Bottom line
know.
is, you're saying Meralco bought several times at 62 without knowing the price will be at 62.
Yes, Your Honor.
That's what you're saying.
Yes, Your Honor.
Okay. And because it bought at 62, that 62 became the benchmark price for all the transactions in that trading interval, correct?
That is how the WSM price determination methodology works, Your Honor. You sell, or the price is set at the highest marginal price of the plant that clears.
Now, what is the definition of a contract? A contract is a meeting of minds between two parties,
That's
at least.
correct, Your Honor.
Okay. When Meralco says, sell for me at 62, and Meralco buys at 62, there is only one buyer and seller, correct?
Your Honor, this is different in the sense, Your Honor, the transaction between TMO and Meralco is already done. They already have a bilateral contract. They have already agreed on how they will be paid.
But why would Meralco buy at 62?
Your Honor, precisely, it becomes complicated because of the must offer rule. The TMO must offer at the WSM, Your Honor, its capacity, even though it is fully contracted. And Meralco, the moment it withdraws power, Your Honor, all Meralco says is, I need X amount of mega hours.
Okay, let's not...
So it will just withdraw it, Your Honor.
Let's go, let's say assuming now that, we're talking about a stock market, shares of stock. If the buyer and the seller are one and the same party, that is a fictitious sale, correct?
Because they're in the stock market, Your Honor, the buyer sets the price, and the seller also says what it wants.
If one person does that all, it becomes price fixing, correct?
That in the stock exchange, Your Honor.
That is price fixing in the stock exchange.
No, Your Honor, that is the regular trade in the stock market.
You mean to say, I can do that, I can tell my broker, you sell at 100 even if the price is doing at 50, and I will buy at 100 and I have brought the price up?
No, Your Honor, what I'm saying is, if I want to sell my stock, Your Honor, if, for example, the stock is doing at 300, and somebody wants to buy it at 300, this offer and the bid are matched, then we have a consummated transaction.
Yes, but what I'm saying,
But-
the buyer and seller are the same person. The same person, that means the
Yeah,
seller and
yes,
buyer fix the price.
That is price manipulation, Your Honor,
Yes.
because
So what I'm saying, if this were to happen in the stock market, it will be price manipulation. But you are saying it is not price manipulation in the Western because Meralco is blind. It doesn't know the actual price. That's what you're saying.
It doesn't know the price, Your Honor. All of the, by the way, it's not just Meralco, Your Honor. Any buyer, any distribution utility that withdraws power from the grid, Your Honor, does not know what is the price that he will pay for the spot market. They will know it only after, Your Honor. They are all price takers. That is why, to the extent that we can, Your Honor, Meralco, you enter into bilateral contracts. The problem arises, Your Honor, because of the mass offer rule. More than that, Your Honor, the question is, why did it hit 62? Because several persons violated the USM rules, offered and did not run, offered and ran but did not run the maximum. That is the proximate cause, Your Honor.
So do you agree with me that that kind of rule does not allow the transfer of actual cost, but allows the transfer of a fictitious cost to the consumer?
Your Honor, that cost per the USM operation becomes the real cost already, Your Honor.
No. The real cost is what the parties agreed. But the regulated price is determined by USM not. It goes up to the last transaction, correct?
Your Honor, for the bilateral quantities, it is what the parties agreed.
Yeah, but even in that USM, there is a trading interval and several transactions within that 1 hour interval, correct? And the prices are different.
That's correct, Your Honor.
And the rule of USM is the last price will govern everything, correct? And the last price is
For-
always the highest price, correct?
For that particular trading interval, Your Honor. That's
Okay.
correct.
The last price is always the highest price, correct?
That's correct, Your Honor.
Because it is the highest price that is dispatched last, correct?
That's correct. That is what.
So
That is the
Yes.
price. That is
my
the real
question
price.
to you is, does that comply with the law? The law says only the actual cost will be charged to the consumer.
Your Honor, the USM is provided for in the law.
No, but because those rules are not in the law. That's only a rule adopted by the WESM board.
No, the USM, Your Honor, is provided in the law.
That's created by the law, but the rules that the last price will apply to all the rest, that's only a rule. That's not in the law.
Yes, Your Honor, but
So my question is-
the rule, the price determination methodology, Your Honor, that was proposed, was approved by ERC.
Yeah, I know, but are those rules compliant with the law? The law says only the actual least cost will be passed on to the consumer. So
Your
is
Honor-
that the actual least cost?
Your Honor, the USM is supposed to work, no? If there is sufficient supply.
No, my
It's
my
supposed
question
to
is
be
simple.
the
Do you
optimal
agree that that kind of rule will allow the transfer price at least cost to the consumer? Or it will allow the transfer of a regulated price higher than the actual list price?
Your Honor, the USM is supposed to operate on a free market, Your Honor. Now, the remedy,
no.
I
My
understand
question-
where you're coming from, Your Honor. I think the remedy precisely, that's why the EPIRA Law repeats in so many sections.
That's why my question-
Market, abuse, and anti-competitive
That's why my
behavior.
question to you, do you agree or disagree that that rule of WESM complies with the EPIRA law?
Your Honor, that is the EPIRA.
But you are complaining against
yes,
that
Your
rule.
Honor, we think-
So you do not agree with that rule?
Yes, Your Honor, we think
Okay.
the must offer rule
Should be deleted,
should be deleted insofar as those that are fully
contracted.
and it should only apply to those who have spare or
Yes.
reserves to offer to sell.
But even in those with companies that have spare, the the last price should not apply to all the other transactions, correct?
Your Honor,
It should-
a while ago, Your Honor, our position, Your Honor, is that it should just pay as bidded, Your Honor, if somebody bidded
Yes,
at
as
one.
bidded.
Yes, Your Honor, but
Just like
here-
in the stock market, whatever is the bid in that particular transaction, correct?
But now, Your Honor, the structure of the WSM, Your Honor, is that you pay at the maximum.
Yes, do you agree
bid
or
price.
disagree with that?
Your Honor, we want the rules to be changed.
You want
Right?
it to be actual price
We want
per
it-
transaction?
First, Your Honor, our wish is that if those that are 100% fully contracted
They shouldn't-
and do not have any
No more
capacity,
must offer.
they should not even
Only
offer
the
and
net,
participate.
whatever they have not contracted will go to the WSM.
Yes, Your
And
Honor.
in the WSM, it must be based on the actual price
It must be based
per
on
transaction.
may based on what they bidded, Your Honor, and I suppose at that point in time they will bid to cover not only their cost but even their profit, because right now, Your Honor, the bids,
No, because okay,
do not have any relation, any economic relation. Some bid at zero or minus.
yes,
even.
yes. Okay. Now, in the trading interval, there is an offer at 5, there's an offer at 10, and there's an offer at 62. All of these are taken. Okay. Do you agree that it should be what should be passed on to the consumer should be the weighted average of this per transaction, not the 62, correct?
Your Honor, you don't even want to average because
Okay, you don't want to average actual. So
because-
if this
because-
one is only 5.5 megawatt at 62, that's it. This one, 5 pesos at 100 megawatts, that will be passed on to the consumer. And the other one at 3 pesos at 1,000 megawatts, that's what's going to be passed on to the consumer, correct?
if I
That's
have,
the best.
Your Honor, if I have the will and the power to change the rules, that's what I will do, Your Honor.
Okay, thank you, counsel. Good.
Okay. Justice De Castro. Will you tell us again why Meralco decided to bid to offer the 62 price that you
Your
mentioned?
Honor, Meralco has a bilateral contract with TMO, and the whole capacity of TMO is contracted with Meralco. And under the contract, it will be Meralco that will determine the times that the TMO will be dispatched. The plant capacity factor, Your Honor, or the percentage of utilization is 40%, Your Honor. And we do not want that 40% to be used during off-peak hours. So the strategy, Your Honor, so that the best example, Your Honor, is, let's say in a class, Your Honor, in a classroom. If you want to be called, you sit in front. If you do not want to be called, you sit in the back. Maybe the one who sit in the front will grade a grade of 1, 1.5, 175, and so on, up to 5. Now, Your Honor, usually you know who will be present. But unfortunately, Your Honor, several absented themselves, offered, did not run, or did not run to the maximum. Now, the one at the back was called 5. The rule of the game is that the last one who was called, that is the grade for the class. So if the one who was called at the back, who did not want to be called, is 5, the grade of the whole class is 5. That's how it works, Your Honor.
Is the basis of Meralco in setting it at 62? Is there a basis, or is that just an arbitrary?
No, Your Honor, there is a basis. They computed, Your Honor, that if there is a computation which came about to that if you use thermomobile, Your Honor, the capacity immediately at the very beginning, and therefore you don't have any more power for peaking, and you buy it all from the WSM, it will be more expensive, Your Honor. That's why they wanted it to fix it at the highest possible price, Your Honor, so that it won't be called.
Do not want it to be called. That's why you
Yes, Your Honor.
set that at that high price.
Yes, Your Honor. And
Now, you know that applying the rules of WESM, there is a danger that you may be required to pay that amount.
Your Honor,
There is that danger that you may have to pay that high price.
that is true, Your Honor, that is the price if there is really deficient capacity, Your Honor. And we're saying that perhaps that can be avoided if we take away with the must offer rule, Your Honor, so that those who really are fully contracted and do not really want to be dispatched at that price will just get out of the classroom, Your Honor. And that it will just those who have something to offer that should attend that class, Your Honor.
That is a wish, but the rules as they stand now may, as it has happened in the past, you were compelled to pay a high price.
That's correct, Your Honor, and precisely what we're saying is you look at the proximate cost, Your Honor. Why so many of those that have offered, why they did not run? Or those that actually offered, Your Honor, certain quantities, they did not run them at the maximum quantity. Senator Osmeña at the Senate hearing mentioned, Your Honor, that had one plant run an additional 300 megawatts, and it was already on stream, it was already running. The amount would not have reached 62, but only 12. But wonders of wonders, Your Honor, the one at 62 was called for only 0.5 of a megawatt, instead of having that plant, which was already running the full capacity, Your Honor. We don't understand ourselves, Your Honor, why TMO was made to run at 0.5 of a megawatt when existing plants were already running at much cheaper price. We don't understand, Your Honor.
So there are many contingencies beyond your control. Now, assuming that Meralco cannot pass on this high price to the consumers, would you still take the risk of paying a high price by bidding at 62, knowing that, I'm trying to say that, assuming as a business proposition or as a business decision, would you have done the same thing if you cannot pass on the cost to the consumers, that you will shoulder it, assuming that you will shoulder it? Will you still take that risk of setting a high price and ending up paying for that high amount of generation cost?
Your Honor, insofar as Meralco is concerned, we have expressed our reservations, Your Honor, and our wish that certain rules be changed, Your Honor. Right now, these are the rules of the WESM, and the only way, if you want to avoid being dispatched, you bid at that high price, Your Honor. One, Your Honor, the bid at that price always took into consideration what the market forecast was. In all of this, Your Honor, what we are talking about now, the relevant period for November to December, there was only one day, Your Honor, and only for 8 hours was the yellow alert bannered, Your Honor. In all of these times, it was white, meaning there was sufficient reserve in the system, Your Honor. So we feel, Your Honor, that Meralco has a right to rely on what is being given to us, Your Honor, by the system generator as the status of the power grid, as well as reliance that the other members and participants in the WESM should comply with the rules, Your Honor. Meralco complied with all of these rules.
Yes, my point is just that could Meralco have been more prudent if it cannot pass on the cost, the generation cost to the consumers? Could it have adopted the same attitude and bid a high price, knowing that in the end it will be the one to pay and not the consumers?
Your Honor, the problem is, if you look at it, Your Honor, nobody wants to bid high, Your Honor, if you're going to take it, Your Honor. But you look at the market conditions, Your Honor, what are the forecasts, and so on, Your Honor. And as long as this is the system, Your Honor, there is no way for a fully contracted generation company, Your Honor, to avoid being dispatched at non-peak hours when it is supposed to be a peaker plant. What will happen, Your Honor, I think the rates will probably become higher, because then there is no use on contracting a peaker plants. Then you will just go by the WSM, Your Honor.
That brings us to the issue of whether the generation company should be also regulated by government. Justice Feliciano mentioned earlier what are the conditions for a company that provides service to the public should be considered a public utility that is subject to government regulation. But modern society has progressed beyond our imagination. And shouldn't the court be progressive in its thinking and look at the present situation, the development in technology, and all of these, the changes in the way business is conducted? We have seen how the chain, the four areas in the industry are connected, so intertwined that you cannot segregate one from the other. Is it a reason for us to review jurisprudence and come up with a new guideline on whether or not a company is providing service to the public and should be regulated as a public utility?
Your Honor, our assertion, Your Honor, to the determination whether a business that is affected with public interest should be a public utility or just a public service company is with the Congress, Your Honor. But may I just quickly add, Your Honor, it has been pointed out that the GenCos can and are regulated, Your Honor, not as public utilities, but as businesses affected with public interest as declared by EPIRA Law, Your Honor. One, if I may be allowed, Your Honor, it is only the price, Your Honor, that they are charging, Your Honor, that are not subject of regulation of the ERC once there is retail competition and open access. But the other aspects of their business, Your Honor, reportorial requirements, guidelines on certain operations, and I suppose even profits, Your Honor, because there is a provision later on excess profits, Your Honor. There must be some guidelines how you determine excess profits. That can be subject of a regulation, Your Honor. There is also several provisions in the law, Your Honor, where indirectly the distribution utilities, Your Honor, when they enter into bilateral contract supplies, and this is only with the GenCos, are subject to review of the ERC. So the contract with the GenCos are reviewed, Your Honor. Not only that, they are also subject to post-verification review later on, Your Honor. In addition to that, Your Honor, the ERC has sufficient powers, Your Honor. One, with respect to the certificate of compliance, the ERC can provide certain conditions with respect to this so-called certificate of compliance that the GenCos need to comply with. There is also the ERC has ample power, Your Honor, to penalize the abuse of market power. There is also ample authority to monitor the activities, particularly with respect to pass-through bulk purchase of power. There is also ample authority with respect to requirements of report and data, inspection of their premises, books and records, and there are also ample penalties, Your Honor, with respect to issuance of injunction, issuance of divestments, disgorgement of excess profits, impositions of fines and penalties, and a violator of these provisions, Your Honor, can be fined to the extent not exceeding double the amount of damages cost. So that is all in the law, and this can all be properly implemented, Your Honor, by appropriate regulations that can regulate the gen cost, Your Honor.
Okay, you can put that in your memorandum.
I will, Your
to
Honor.
explain why that can take the place or that can be a substitute for what the Constitution requires for
I will,
public
Your Honor.
utilities.
I will, Your Honor.
Thank you.
Del Castillo.
Just a few follow-up questions on the cost of the unusual increase in electricity, which you labeled as aberration earlier, 4.15 no? Pesos per kilowatt hour. As your principal has said that the principal cost of the unusual or the stiff increase in electricity cost was the simultaneous maintenance shutdown of Malampaya and other GenCos. Couldn't this situation have been avoided? I mean, you just mentioned earlier that the ERC has power over these GenCos except the pricing. So you couldn't, for instance, well, you said that Meralco made representations with the GenCos and that you were just successful in negotiating with one GenCo. What was the reason why you were not successful in the other GenCo?
Your Honor, the other GenCo, Your Honor, we were told that their machinery was already scheduled for maintenance shutdown, that the people who were flying from abroad and their consultants were already made their arrangement, and therefore they could no longer reschedule or delay the maintenance. Your Honor, the scheduling of the shutdowns, Your Honor, is the function of the system operator or the NGCP, the National Grid Corporation, Your Honor. And from what I understand, upon request, Your Honor, of the COMELEC, some of them, Your Honor, had scheduled shutdowns during the barangay elections, Your Honor, in October. They were asked to defer their shutdowns for that period, Your Honor.
Yes, but the law, Section 23 of EPIRA Law, directs you to provide the least cost of electricity. So the obligation is on your part to at least see to it that the electricity that you supply to the consuming public is at the least cost. So you should have perhaps made a stronger representation with the ERC to perhaps exert pressure on the GenCos. Because you were just saying earlier that just one GenCo caused all this problem.
Your Honor,
can you imagine if the maintenance shutdown of that GenCo were deferred a little later, just for last November? We would not have this problem right now.
Your Honor, we do not have any authority with respect to this GenCos, Your Honor. The one that has the authority to schedule their shutdowns is the system operator, Your Honor.
Yes, but ERC, you were saying earlier, has a regulatory function also over this GenCos. Then they could have exerted pressure on the GenCos to defer at least the maintenance outage.
Your Honor, there were several meetings, as I understand it, Your Honor, that were precipitated either by the Department of Energy and ERC, Your Honor. Maybe they are in a better position to give this honorable court answers with respect to that. But Meralco participated in those coordination meetings, Your Honor. And in fact, in those meetings, I've indicated what are the mitigating factors or action that Meralco took during those meetings, having the gas plants, the natural gas plants, run on alternative fuel. And as we mentioned, Your Honor, we tried to convince two to reschedule their scheduled shutdowns. One agreed, the other one, because of we were told that they were already, the consultants, Your Honor, were already made arrangement and that a certain warranty, Your Honor, was going to expire if they do not repair them right away. So we could not do anything at that point, Your Honor.
But you knew this problem beforehand. You
Oh,
knew
yes,
already
sir.
the scheduled maintenance shutdown, even ERC, and yet you allowed it to happen.
Your Honor, we could not do anything, Your Honor.
Delay at least the shutdown of the maintenance shutdown of at least this one power plant that you were saying earlier would have mattered. But you never did.
We requested, Your Honor. We requested, Your Honor.
And ERC just
No,
did not do anything about it?
No, that is a private effort of Meralco, Your Honor. We are not aware what the ERC or the Department of Energy did, Your
No,
Honor.
that's why when you were already informed that this power plant would not be accommodating you, you should have gone to ERC and for ERC to apply pressure on this power plant because they have regulatory function over these power plants.
Your Honor, there were coordination meetings and attended by different parties, and all of these different shutdowns that could affect the Malampaya were all in the agenda, Your Honor.
Okay, thank you, Counsel.
Justice Abad, Justice Pepe. Justice Abad first. Okay. You want to toss coins? You can also toss coins.
I just tried to be brief also. Before this aberration, in the years before the aberration, were the rules concerning power supply to Meralco working for the public interest? Have there been questions raised as to manipulation of the market or promoting what they call that, or encouraging connivance among the power generating companies?
Your Honor, I am aware only of one particular instance, Your Honor, and this is, in fact, we have submitted that particular decision of the ERC, Your Honor, as our Annex 17. This is an incident, Your Honor, that we're in September.
In what year was that?
September 2006, Your Honor, where Meralco complained to the PEMC, Your Honor, that they noticed certain activities, Your Honor, and it pertained to the trading activities of PISALM at that time, Your Honor. PISALM had, I think, 4 or 3 trading teams. And it, from what the records indicate, Your Honor, the president of NPC wrote to the president of PISALM complaining why they are losing in their trade at the WSM. And apparently, Your Honor, the traders of PISALM were gathered together, they were talked to, and immediately that month, the price of the WSM purchases increased to 30 pesos, Your Honor. This was the Market Surveillance Committee of the WSM looked into it. They recommended that and found that PISALM acted anti-competitively and wanted them sanctioned. This was sustained by another committee, Your Honor, but when it was brought to the ERC, the investigating unit, somehow, Your Honor, the end of the story was they were just severely or sternly warned.
So the system was fixing itself.
I would
In
say,
that
Your
way.
Honor, that insofar as we're concerned, Your Honor, because if you look at our purchases from the WSM until these aberrant months, Your Honor, they were more or less reasonable, Your Honor.
But after that, after 2006, has the system worked smoothly up to November of 2013?
As far as we know, Your Honor, relatively well, Your Honor.
Well, this system that was in place from 2006 to 2013, was this still the system that you applied when this aberration took place? Did you change the rules, or did you just do what you have been doing before the aberration?
We were still doing the same thing, Your Honor, except this time, Your Honor, there are the outages, and what we have recently discovered, Your Honor, are violations of the WSM rules by certain GenCos, Your Honor, who made an offer but did not run, or offered but did not run their maximum capacity.
Right. So it's not really, it's just this particular incident of November 2013 that has caused this problem. The rules that were in operation have been working well until this particular occasion arose and people complained about the sudden increase in the rates that Meralco will charge the consumers. Is that correct?
That's correct, Your Honor, but like anything, Your Honor, there is always room for improvement, and the comments that we have, that I have made earlier, Your Honor, to be an improvement of the rules, Your Honor.
My point is this, really. Because from the discussion that you had with Justice Leon and even Justice Carpio, it seems to me that they are going into the details. They're going to the hour-to-hour transactions that takes place during this period on how everybody behaved or things like that. So, do you think that the Supreme Court should, who has primary jurisdiction to determine whether there was some kind of misbehavior or market abuse in this particular crisis period that occurred in November of 2013?
It is our submission, Your Honor, that under the EPIRA Law, it is the ERC that has the primary jurisdiction, Your Honor, to resolve
Has
this
the
particular
ERC, since it's the ERC you said that has jurisdiction to look into this, has the ERC in fact done anything to look into this to determine where there has been market abuse or what do you call that, trying to prevent fair competition?
My understanding is they are currently doing that now, Your Honor. Their investigating unit is active and is doing that right now, Your Honor.
Is it proper for this court at this time to be the one to conduct a parallel investigation and determine whether or not in this particular period, November and December, there has been occasion for misbehavior in the marketplace?
It is our submission, Your Honor, that it is precisely the ERC, Your Honor, that in fact we felt that the petitioners are foisting upon this court to make to investigate these facts when it should be the ERC that has the personnel, the experience, the competence on this industry, Your Honor.
Well, as a matter of fact, we've been spending I think it will be about 8 hours already on this case, looking into this, trying to investigate these matters that I don't feel, well, I admire Justice Leonen for being able to look at all of this, but as far as I'm concerned, I don't feel I have the competence or skill, or most of us here have the competence or skill to determine whether this hour-to-hour trading in power, whether within our competence to determine whether this being properly done or not. Maybe ERC should act on it, and then there can be an appeal to us, and then we will have some basis for making a decision or a ruling whether or not to uphold ERC or to reverse the decision of the ERC if we find that it has not made the proper, not done the proper action. Do you agree with that?
That's
Well,
precisely our position, Your
My
Honor.
other point is this. I was going to ask. We have not decided, and we have not even discussed whether or not to lift the TRO. I think you're asking us to lift the TRO in this case in the meantime.
That's correct,
So
Your Honor.
I'm interested in finding out what are the repercussions of the court keeping the TRO in place and later on lifting it. What will be the repercussions?
Your Honor, the first repercussion that we see, Your Honor, that concerns us is this coming months, the coming summer months, which are the peak months. The demand for electric power, Your Honor, will certainly increase. The supply, because the hydropower plants, Your Honor, most likely will not be available because they will conserve the power, the water, Your Honor, for drinking and for other purposes, Your Honor, rather than for energy. So there will certainly be tighter, Your Honor, supply of electricity. And also, Your Honor, I've already mentioned that the dollar, the fuel cost, Your Honor, is dollar-based. The peso deteriorated already by 2 pesos and 11 centavos, or almost 5%. If you maintain, Your Honor, the frozen generation charge at 5.67, we really doubt, Your Honor, whether we can source all of the power that we need when we need to have peaker plants, oil plants, or bunker plants to be running to pick up the slack during the peak months, Your Honor. With 5.67, Your Honor, we are doubtful whether we will have sufficient supply of power during those periods.
But if the power companies, the GenCores, let us say, just as an assumption, I'm not saying that may be the case. If there is connivance or market abuse during that time, what will be the remedy, on the other hand, of the consumers to make sure that they really pay the fair amount?
Your Honor, the way the EPIRA is structured, Your Honor, the remedy is really post facto, Your Honor. Meaning, that's why there are so many provisions, Your Honor, with respect to anti-competitive behavior and market abuse, Your Honor. And the penalties are substantial, Your Honor. A violator can be penalized
Can there be
up
refund?
to double.
Can there be an order of a refund?
Yes, Your Honor.
Has that happened before, where the Meralco was ordered to make a refund to the consumers?
Yes, Your Honor. I would have said unfortunately, but that has happened, Your Honor.
Why is that unfortunate? Not for us. Unfortunate for you.
For
For
my
Meralco.
client, that is, Your Honor.
Well, anyway.
But that has happened, Your Honor, and I am certain, Your Honor, that the recipient...
So what will happen if the TRO is lifted? Immediately, these amounts will be collected from the public.
Your Honor, there
The
are
people will have a problem there.
I understand, Your Honor, that there are some discussions, although I'm not privy to them, Your Honor. I just was told that the amount of the increases are substantial, Your Honor. And I understand there's some discussion between the department and some GenCos, Your Honor, on how to be able to stretch this out, Your Honor, and stagger it, Your Honor.
But actually, as I heard from them, that what they charge is not really, is really part above their cost. If you say they're not really going to lose money if they lower it lower than 62, because that is not really their cost. As you said, it's something like 8 centavos, something. They make a profit already at 8 centavos, so there will be no devastation, financial devastation for them.
I understand, Your Honor, that Secretary Petilla is undertaking that effort, Your Honor.
Because they need also public sympathy and support. Take it. Otherwise, everybody might be a loser. Thank you very much.
Justice Perez and then Justice Velasco.
First, I would like to commend Counsel for contributing to clearing up all the issues. At least personally, I came in without any clear idea about what the whole problem is. Now I know a little about it. From what I got from the discussions, the root of the problem is really in the WESM rules, in the manipulation, let us say, of the WESM rules, or the inadequacy of the WESM rules to prevent market manipulation. And you very well presented the position of Meralco such that, as I understood it, Meralco is not to blame. It is really the working of the WESM rules which caused all the problem. And then you referred to the remedies post the increase, which will allow ERC to look into market manipulation, etc. My question is, cannot the ERC look into the manipulation of the WESM rules even before the implementation of the so-called automatic increase? Because I sense that if you are correct in saying that it is really the ERC to blame, then I think that you were part of the problem, because instead of urging or moving the ERC to do its work in setting aright all these things which were done erroneously or wrongly, you instead petitioned the ERC or wrote the PRC to effectuate or to put into effect what you point out now was a manipulation or the inadequacy of the rules. Could you not have at that point, instead of writing a letter, of course you say for a graduation of the increase, instead of writing that letter which which impliedly is an acceptance of what has happened, could you not have at that point wrote a letter instead asking the ERC to restudy what has happened in this sudden aberrant circumstance?
Your Honor, first, I'd just like to mention, Your Honor, that under Section 43, the one functions of ERC is to monitor the activities in the generation and supply of electric power industry with the end in view of promoting pre-market competition and ensuring that the allocation or pass-through of bulk purchase costs by distributor is transparent, non-discriminatory, and that any existing subsidies shall be divided pro rata among the retail suppliers. So there is that function of monitoring, Your Honor. And right. For Meralco, Your Honor, in a October 10 meeting of the stakeholders, Your Honor, Meralco precisely suggested the use of WESM administered price, meaning, Your Honor, when prices are administered by the WESM, Your Honor, they do not rely on the price determination mechanism. This happens, Your Honor, if there is, let's say, a typhoon, Your Honor, or in cases of international or national security emergencies, Your Honor, that is allowed. But unfortunately, the rules right now as they are written did not consider the fact that a substantial fuel supplier, Malampaya, as well as with the overlapping shutdowns of other plants, were not under the rules sufficient to impose administered prices, Your Honor. But that was the first impulse of Meralco, and that was what they suggested, that we should, that during the Malampaya shutdown, as there was going to be a severe shortage of supply, that the prices be administered. And by administered, Your Honor, these are certain prices that are determined by, Your Honor, in relation to prices 4 days, I think, Your Honor, that are normal and not affected by the unusual circumstance.
In other words, Counsel, at that point in time, you did not have any choice except to write that letter asking for...
yes, Your Honor, because at that point in time, the bills already came, and we only came to... that was when they saw the bill, Your Honor, and they saw it was substantial. They immediately went to ERC and asking for permission to stagger it, Your Honor.
And so nothing can be done anymore if and when the court decides to remand this matter to the ERC to do what it failed to do, or what you suggested in your argument ought to have been done.
Your Honor, on the part of ERC and WESM, Your Honor, the rules did not define that as an emergency, Your Honor. Maybe, again, that's one of the possible ways, Your Honor, of tweaking the so-called rules of the WESM, Your Honor, so that this could be considered later on when a situation like this will arise. Prices can be administered instead of allowing the skyrocketing of prices, Your Honor.
And the tweaking is not with this court, for this court to do, but for the ERC to perform.
It is for the DOE, ERC, and WESM to do, Your Honor.
And in the meantime, would you agree that while the tweaking is being done, that the TRO should remain in place?
Your Honor, the problem of the TRO remaining in place, Your Honor, as I mentioned, is the coming months, Your Honor. January and February, Your Honor, are the usual low months. In fact, as I mentioned, the generation cost for the January supply month is 5 pesos and 53, Your Honor. It already went down by 14 centavos. That is likely going to be the case also for the February supply month. But by March, the demand will increase by 8, and then by April by 16%, and by May at 17%, and June at 16%. And the supply, Your Honor, the hydropower plants will not be available. With the workings of the demand, increase in demand, and the decrease in the supply, it is very easy to see where that would lead us if that price, Your Honor, of 5.67 remains.
Your submission, Counsel, is that the TRO should remain effective insofar as the November-December bills are concerned, but insofar as the coming months are concerned, let the workings of the WESM proceed, as it has been properly working before, not as aberrantly worked.
In fact, our plea, Your Honor, is including the November and December supply months, because there are certain suppliers and certain persons that need to be paid. For one, Your Honor, I don't think there is any dispute, Your Honor, that the Ilian plant, Your Honor, and the Santa Rita plant, Your Honor, these are natural gas plants. They were asked to run on liquid fuel. One run on biodiesel and one run on condensate. The total price for that, Your Honor, is 103 pesos per megawatt. That is already incurred, and that needs to be paid, Your Honor. Now, we still have to determine what is the real cost, Your Honor, for the WSM purchases, Your Honor? What is the real cost, and what could have been windfall profits, Your Honor? But still, as our submission, Your Honor, is that whatever it is, Your Honor, there is always the possibility of a refund. And the refund, Your Honor, is for the GenCos, Your Honor, who will be paid the generation charge are all solid, Your Honor. And I'm sure if they need to cop up the money, whatever is paid to them, they will in the future be able to effect the refund also, Your Honor.
Yeah, but the TRO works as well against your creditors, and therefore they cannot claim or file a money claim against you for the things that are TRO'd.
Right now, Your Honor, there is no TRO yet against the GenCos and the others, Your Honor. It was prayed for by the petitioners, Your Honor, and we are joining them if at all this court will maintain that TRO or injunction, Your Honor.
Thank you, Chief.
Justice Velasco.
Counsel, it's your position that Meralco directed Terma Mobile to make a bid of 62 pesos per kilowatt hour, and this is during the off-peak hour. Is that correct?
That's right, Your Honor. When a
and your reason
plant,
is that you want it dispatched. You do not want it dispatched, right?
yes, Your Honor, because it is an expensive plant, you would want it to dispatch it only on peak. On
Okay.
non-peak, Your Honor, your baseload plants and mid-merit plants are already sufficient to deliver the supply, Your Honor.
And it is a stipulation in the PSA that Meralco can nominate or order or direct Terma Mobile to make a particular bid at the price that it wants, right?
For all of the contracted plants, Your Honor, it is usually the buyer, Your Honor, that makes the determination when the particular supply is needed, Your Honor.
Why did Meralco choose 62 pesos? Why not 100 pesos?
That is the bid cap, Your Honor, 62.
That's the cap.
That is the cap, Your Honor.
So, Meralco was aware already that that is the cap when it directed Terma Mobile to make a bid of 62? Was it aware already?
Yes, Your Honor. That was the cap so that it will not be dispatched. That was the strategy, Your Honor.
And during the peak hours, what was the directive given to Terma Mobile? What price should it bid?
To bid at the variable cost, Your Honor.
What is that?
That's about 6 pesos to about 8 pesos, Your Honor. That's my
Well,
recollection.
somebody said it can be zero, negative.
Your Honor, for some base load plants, Your Honor, some because they have to run, Your Honor, and these are running 24/7, Your Honor, for the whole year except for the time that they are maintained, where their plant capacity factor, Your Honor, is around 85 or 90%, Your Honor. Those are the ones that sometimes bid at zero or even minus, Your Honor, so that they will continuously be called immediately.
Has Meralco made an instruction for Genco to bid lower than the price subject of the PSA?
Whatever is the bid, Your Honor, in the WSM is immaterial because the parties, the contracting parties, Your Honor, the Genco and Meralco will settle anyway on the basis of their agreed contract price.
The reason why I'm asking is that you want this dispatched also. That's why a DU can just order Genco to make a very low bid. Is that correct?
That's
That is really the reason behind all these directives given to the Genco, right?
That's correct, Your Honor. That's precisely because of the must offer rule, Your Honor. What has happened is that the pricing of the offer is really more of a strategy if you want to be dispatched. If you want to be dispatched, bid at zero or even negative. If you do not want to be dispatched, you bid at the highest. And we're saying, Your Honor, and that is why, Your Honor, it's the bidding does not follow a logical or economic pattern. Whereas if it were only for the net excess, then the bids will be more rational. Then you will bid for your excess. It depends on you. If you just want to recover your variable, then you bid your variable cost. If you want to make a little profit or including your fixed cost, you tuck that in. If you want to make a profit, you also tuck that in. That is,
Okay,
if it is a net pool.
Yeah. ERC was the one which promulgated the WSM rules, right?
It was approved by
Approved?
the ERC, Your Honor.
ERC. It was approved, okay.
Yeah.
And ERC, but what body actually promulgated it, subject to the approval of ERC?
I don't really
You're not sure?
know.
Anyway.
I know it's was
PEMC?
the Department of Energy together with PEMC, Your Honor, that prepared it, but subject to approval of ERC, Your Honor.
ERC. ERC is
That's
a
my
quasi-judicial body?
Yes, Your Honor.
Okay, your position is that Meralco played by the book, means say just follow the rules,
Yes, Your Honor.
specifically the WSM rules, okay? And then you're saying you just follow the mass offer rule, and which is contained in section 3.5.5.1, right?
That's correct, Your Honor.
And the rule says all generating companies to offer for all hours all their available capacities to the WSM, right?
That's correct, Your Honor. That is the concept of the gross pool, meaning everybody should offer all of their capacity if they are available, Your Honor, and to the maximum.
But I heard that this may have some merit, that this supply of electricity is already subject of a contract, a bilateral contract. So why should that be considered as still available and covered by the must offer rule? So if you look at this as a lawyer, a practitioner, or even a judge or a magistrate, then this is supposed to be outside the rule already of the must offer rule, because it's already taken out of the available electric supply. Is that a correct interpretation?
That's the WSM rule, Your Honor. Precisely, we are saying
Yes, but
that
the rules can be subject of interpretations unless it's very clear. But
it's
then we know for a fact that this supply of electricity is already subject of a contract between two parties, and yet it's still covered by the must offer rule.
yes, Your Honor, except that they are told to declare the bilateral contracts.
Even
And
then, but how can we how can a body do an act which will possibly be in breach of an existing contract? Say, for example, the GENCO agreed to 8 pesos per kilowatt hour, and then the highest cleared price will turn out to be only 5 pesos. So in plainly, the result is that there's prejudice to the GENCO, and that's a breach of the obligation under the contract, right?
No,
of
Your
course,
Honor.
Meralco will not be affected because you just pass it on to the consumers, but the GENCO may be adversely affected by the operation of this rule. Isn't that iniquitous or unfair? And
No.
clearly a breach of the obligation of contract?
No, Your Honor.
It's not?
The bilateral quantities, Your Honor. When let's assume, Your Honor, first, if you're 100 fully contracted, you have to tell WSM that you are by the total quantity, so that will all be settled outside of the WSM. That's settled based on the contract of the parties. So even if the price at the WSM is low, you will still pay at 8 if that is the price you agreed.
So why
If
was
it
the
is
supply of
62
Thermamobile subject to the highest cleared price?
Your Honor, it's just set the price, but the settlement between Meralco and TMO is still the contract price.
So we
all the
just
time.
have to make use of the price subject of your PSA with Thermamobile.
But
8 pesos.
That is exactly what was built by Thermomobile, and that is exactly what we pass on to the consumer, Your Honor.
So why is there a spike in the price of electricity? If that's the case, if that's really the amount contracted for and which was delivered to you and you agreed to pay for the supply at that rate, why is 62 that's being applied?
For the bilateral contracts, it is the 8 pesos, Your Honor. But there could be West End purchases also, Your Honor.
Oh, so you're referring to the
West
other
End
purchases by Meralco?
Yes, Your Honor. It's this
at the
other
spot market.
at the spot purchases will be paid at the marginal clearing price, Your Honor.
So what percentage is that of the total electric supply that Meralco needed at that time?
Your Honor,
It's only 10%?
For the November supply month, it came out to about 11%. For December, it came out to about 14%, Your Honor. Whereas
So-
our average for prior months and prior years was about 8 to 7%, Your Honor.
So the 11% electric supply at 68 immediately resulted to a spike on the overall price of Meralco to the consumers?
Yes, Your Honor, not only for Meralco but also for the other distributors, Your Honor.
So you're saying actually that the main culprit is the application of the WESM rules, that it should be changed, it should be modified.
That is one, Your Honor, but also there are what we assert as the violation by other GENCOs of the WESM rules, Your Honor.
Thank you, Counsel.
Just let me clarify again for everyone. The temporary restraining order that was issued last December 23 only covers November 2013 generation charges and not and then for no other period that were reflected in the December billings. That's clear. And that we want to assure everyone also that the court is not insensitive to the time element here. That's what, so that if there is any concern that the time element will be a major problem to the supply of electricity because of the court's intervention, I think everyone can be rest assured that the court is doing its level best to address the legal questions in this petition. Is that clear enough? And only on that question, Justice Leonel, because I want to start some questions and then I'll give it to you. Okay. Is that clear?
Your Honor, our understanding per our manifestation that the TRO, the spirit of the TRO issued, covered also the December supply month, Your Honor.
Justice Leonel, only the charges that were
That's for the
described
November
in your December 5 letter. Your December 5 letter covers only the November generation charges, which were reflected in the December billings, right?
That's correct, Your Honor.
That's correct, and that's it only.
But our interpretation, Your Honor, we thought that that was the spirit of the TRO of the court.
Okay,
That's
Justice
why,
Leonel will explain some more.
I wonder who the lawyers are that interpreted the TRO, but it was very precise. Letter A, number 1, Energy Regulatory Commission, etc., are hereby enjoined from implementing its December 9 order, which did not cover December or January, and acting further on the letter request of Meralco dated December 5. Let me finish. Number 2, Respondent Meralco et al. Are hereby enjoined from increasing the rates it charges to its consumers and based on the matters it raised in its December 5, 2013 letter. Counsel, I do not think that you can pressure this court by doing something more than what the TRO has ordered you to do. It says here, from increasing the rates it charges to its consumers based on the matters it raised in its December 5 letter. I do not recall your December 5 covering December rates or January or February or March. And it is a TRO. It is not an SQA, which meant that it was prospective. Whatever was not collected December 23, you deal with your consumers and you deal with your etc.
So I take it, Your Honor,
it
that
escapes us escapes us that you read this as freezing it to something like 5.67. It is not even here. And you're using that now to tell us that our decision will affect the entire power sector when everybody can read the content of the TRO. Counsel, I do not see the point.
No, so then we take the statement of the Honorable
You take
Justice.
the words of the order,
Yes, Your Honor.
not simply our statement. This
No.
order was deliberated by all of us. And it's very clear that the scope is the December 5 letter from your client and the December 9 order of the ERC. You do not take what we say orally. You look at the words of the TRO.
We are going to be guided accordingly, Your Honor.
Yeah, I confirm that because I signed the authorization to release the TRO.
We
Please be
we are
guided,
clarified.
therefore.
We are clarified, Your Honor.
Okay. Now, you are saying that you do not know the WESM membership at present? The PEMC membership at present?
Your Honors, I just know very generally who are what they call trading participants.
But you are not a member of the PEMC?
Meralco is a member of the WESM, Your Honor.
But you are not part of any committee in the PEMC?
I'm not sure.
What committees is Meralco participating in?
I'm not certain, Your Honor.
May I know from any Meralco representative what committees in PEMC it is a member of?
Your Honor, I'm sorry, I don't know. I don't
Maybe
know
by
what-
next hearing you can have a manifestation
Yes, Your
answering
Honor,
this
please.
question. Now, can you go to section 30 of the EPIRA? Okay. I'm asking you to look at the second sentence of the first paragraph that begins with the word the market. And section 30 reads, wholesale electricity spot market. Please read the second sentence of the first paragraph.
The market shall provide the mechanism for identifying and setting the price of actual variations from the quantities transacted under the contract between the sellers and purchasers of electricity.
Okay, now you go to the second paragraph and you go starting with the second sentence which says said rules.
The said rule shall provide the mechanism for the determining the price of electricity not covered by bilateral contracts between sellers and purchasers of electricity, electricity users.
Okay, we have already made much of section 23. I think it is the fourth paragraph, which talks about the duty of the distribution utility. And a distribution utility, I'm sorry, it's the third paragraph, is obliged. And this is therefore a statutory obligation, Council of Meralco,
That's
right?
right,
And you
that's right,
admit
Your Honor.
that. To supply electricity in the least cost manner to its captive market.
That's correct, Your Honor.
All right. Now, you have already stated several times that we do not have jurisdiction over the ERC, and yet you're actually saying that the reason for the spike in the prices is a failure of market regulation. First, you have said that the rules of the WESM, which sets the entire spot market amount to be priced at the marginal clearing rate, is defective because it is not really actual cost, but it is the trading cost which is artificially set at the marginal highest price, correct?
That's right, yeah. Your
Okay, so it is a failure of the regulators to provide for a rule that satisfies the statutory requirement imposed on Meralco to provide least cost of electricity to its customers. Correct?
Your Honor, that the
Yes
WESM
or no?
Yes,
In other
Your
words,
Honor,
you are
but-
dissatisfied. So I am characterizing it as a failure of the regulator who is mandated by the EPIRA to ensure least cost, to ensure that the rules do not prejudice the customers of Meralco.
Your Honor,
Yes.
as we understand it, Your Honor, the price determination mechanism of the WESM, Your Honor, is supposed to elicit the optimal price, Your Honor.
I know. I mean, you are trying to justify Meralco's behavior by saying that the rules are there. But you are basically saying that the price determination mechanism and the WESM rule allowing the last marginal price to be the price at which the entire WESM quantity is to be bought is the one that causes partly the spike in the price, which this does not therefore provide least cost to its customers. And if it were only up to you, if you had the authority, you would not have that rule. Correct?
Correct, Your Honor, but may I just make this point, Your Honor? Look at the proximate cost, Your Honor. The proximate cost is not our bidding at 62.
Yeah, I am not yet talking about proximate cost. I'm talking about part of the causes. Because earlier you had said it is a confluence of factors. One factor is the fact that the rules peg the price at the marginal clearing price.
That's correct, Your Honor.
In answer to the question of Justice Velasquez, where you were saying that the amount of electricity supplied during the contested period was only 11%, I noticed after looking at the pie charts of the entire cost of generation, the WESM 11% translated to about 28% of your total generation costs that you passed on to your customers. Is that correct? In other words, an inordinate amount, a disproportion happened in November.
Because of the aberration,
because of the rules.
Because of the aberration.
Because of and part of it is because there is such a rule that if it were up to you, you would change. Correct?
Yeah, because of the aberration, Your Honor, that.
All right, that's just one.
Yes.
Okay, so you are not able to address the least cost legal standard because part of the mechanism for regulation failed, which is that ERC and DOE and the PEMC system should have provided for costs that should have allowed customers of Meralco to enjoy the least cost as they are entitled to under the statute. Correct?
Your Honor, I am not conceding that Meralco failed to provide least cost to its customers, Your Honor. I'm not conceding
you
that.
had earlier said that you wanted to change the rules.
That's correct,
because
Your Honor.
You wanted to, in fact, lower the cost for its customers. How much clearer could you have gotten a few hours ago?
Your Honor, I'm saying that under the rules of the game as they are now, it is still the least cost.
All right. I know that's your defense. In other words, this is actually my proposal to you. Can you make a manifestation or theorize that actually you, Meralco, will not end up being the bad boy here in this story, but you will rather end up as the hero? Because if it were up to you, number one, the WESM rules that allow the price to be pegged at marginal clearing rate will not be the price at which the spot market will be paid. You said that. If you were to be the hero, is that correct?
That's correct, Your Honor.
All right. I'm not making a conclusion that you did not provide least cost because of your own voluntary act. What I am saying is, had you had factors under your control, you would have actually provided actual least cost to your customers if the rules were different.
If the rules were different,
yes,
Your Honor.
I'm not blaming you for the rules because precisely you told Justice Velasco that you were playing by the book.
That's right, Your
So
Honor.
that was why I was trying to characterize the situation as a failure of regulation. And it's not your fault because you're not the regulator. Do you understand?
Yes, Your Honor.
My second theory that I'm propounding to you, you could have actually provided least cost if there were no breachers of the rules of the Western market by those who did not provide the supply when their capacity was required to be supplied. Is that correct?
That's correct, Your Honor.
Okay, if you had the authority and the will to do so, you would not have provided that. You would not have allowed that situation, correct?
That's correct, Your Honor.
You would also not have allowed a situation of overlapping schedules of maintenance.
That's correct, Your Honor.
If you had your way.
That's correct, Your Honor.
Again, third point, a common question. Is the second characteristic not a characteristic of failure of regulation?
Yes, Your Honor.
Please do not be afraid of ERC.
No, Your Honor.
If anyone here is afraid of ERC, I think you're in the wrong venue.
No, Your Honor. It's the systems operator that determines...
NGCP.
NGCP, Your Honor.
Okay, so do not
ERC.
be afraid also of NGCP. In the same way that I asked you in my first question, do not be afraid to say that ERC was wrong. Now, if there were no breaches of the rules, Meralco would not have had such a fix. And it would not have, if it had only the authority to do so, despite the fact that it had a lot of coordination meetings, it failed to convince people to delay its maintenance shutdowns. And what happened is that the shutdowns happened simultaneously. Is that it? Again, is this a failure
correct, Your Honor,
of regulation?
For one generator, that's correct, Your Honor.
You see, what is happening, Counsel for Meralco, is that when I was reading your petition, you were trying to say to us, the justices, we're the good guys here. These GenCos are the bad boys. These dispatchers are the bad boys. Not entirely bad, but they are to blame for all of this. At the same time, you want us to oust ourselves of jurisdiction over this case when actually we could actually agree with you, strike down those rules that you don't like, and say, NGCP, you should not have allowed the fact that there were simultaneous shutdowns of power plants, or ERC, you should have immediately seen that there were indicators of breaches of the supply requirements under the Western rules. In other words, you might be missing the point that we could actually be your best ally. Can't you see that?
No.
In other words, here in a situation where we have a very much publicized hearing, where everyone is listening, and we are trying to be as transparent as we can, this is your opportunity to tell your story. But yet you say you don't want to tell your story before us. You want to shift the storytelling to ERC. Do you want to reconsider that position?
Only because of the technical matters, Your Honor.
But do you think that we are not capable of understanding basic technical issues?
Not that, Your Honor. It's just that the ERC, because of training and their personnel, Your Honor, and their familiarity.
But I heard somewhere that ERC was saying they don't even have enough personnel to conduct correct monitoring. On the other hand, we've been pouring our time here over the Christmas break and over weekends, pouring over all those volumes of documents. So are you still reluctant to have us try the case fully on the legal issue of whether the legal standards under the EPIRA have been met not only by the private participants but also by the regulators?
Your Honor, with all due respect, Your Honor, our legal position on the matter with respect to primary jurisdiction, Your Honor, and that this court is not a trier of facts.
I know, but in 2006, nobody minded you. You said you were already noticing something in September 2006, and nobody gave you attention. You had already coordination meetings to prevent simultaneous shutdowns. All of your efforts failed. All of your private efforts failed. And now your story is being heard. And we have, if we decide that we have jurisdiction over this case, say that ERC should actually have listened to the indicators you had already been pointing because of their statutory role as regulator and monitor of the market. Don't you think that that would be a good thing to hear? after all the complaints that you have been saying about your voice not being heard?
Your Honor, with all due respect, we still believe, Your Honor, that it is...
No, we don't want to set the price here. We don't want to regulate. We have so much work ahead of us. But if we can set the legal standards for behavior by all the government participants here, we would be doing the entire power sector as well as the consumers a great deal of good.
I don't disagree, Your Honor, because that's, insofar as guidance is concerned, of course, that will be welcome, Your Honor.
In fact, we're the ones who can exempt you eventually, even from your ostensible duty to pay the generation charges that have been billed against you. Is that not correct?
Yes, Your Honor.
Okay. Now let's go to, therefore, I will have to ask you if in fact you are the good guys here. I have some questions that are related to the comments you had made, you had submitted to this court. Let me just... Okay. Least cost manner to its captive market. You have a legislative franchise.
What's that, Your Honor?
When we talk about Section 23, your legal standard for behavior is for you to provide the least cost manner to your captive market.
That's correct, Your Honor.
Okay. And you had stated in your comments that actually what you had tried to do is to contract at 90% to ensure that you at least have enough capacity.
That's correct, Your Honor.
All right. Because you are, of course, aware of the problems of supply. That's why you could not also over-contract. But you thought that the optimal contract capacity would be 90%, correct?
That's correct, Your Honor.
Okay. Now, to what extent, therefore, to what degree of influence would Meralco want to have with respect to assuring the stability of supply of electricity from generation companies? If you could write the rules, how would Meralco be able to participate in such a way that it could influence providing supply stability to its customers?
One, Your Honor, would be sufficient supply, Your Honor, that where the excess will be competitively offered in the Western market, where it is just the excess, Your Honor.
Okay, so if it were up to you, we would not have a national pool. We would just we would not have a gross pool. We would just have a net pool.
A net pool of the excess, Your Honor.
So are you now going to agree with my suggested reading that if we read Section 30 of the EPIRA, okay, with respect to the wholesale electricity spot market, the second sentence of the first paragraph and the second sentence of the second paragraph allows PEMC to create rules only for the net pool? And will the court have enough basis to strike down the rules of PEMC which aggregates the rules even for the contracted amounts?
That interpretation is feasible, Your Honor.
It's feasible.
Yes, Your Honor.
Because, in fact, because you have 72% of the national supply market, Justice Leonen, and 60% of Luzon, you're actually going to be negotiating from a position of strength. And if you're going to be able to contract correctly, you will be able to provide the least cost to your customers. Correct?
That's correct, Your Honor.
If it is just net pool. In other words, if your contractual arrangements were not to be unduly intervened by the must offer rule, then you're actually in a more stable contractual situation.
That's correct, Your Honor. May I just explain, Your Honor,
Yes.
why we are not 100% contracting, Your Honor?
Yes, 90%. You said 90% here.
Yes, Your Honor. Because Just the computation, Your Honor, is that for the what we call in the graph, Your Honor, the trough and the shoulder, Your Honor, as it goes down the shoulder and the trough. If you contract at the maximum capacity, Your Honor, the amount not covered by your demand, you will be paying a capacity fee and fixed operating and maintenance costs.
Okay.
And you balance that out with your peak demands. Our calculation, Your Honor, is that you are better off by this present strategy that we have.
90%.
Of just 90.
Correct.
Of 90%, Your Honor, with respect to the peak.
Because power plants are a different creature. It takes so much money to start them and to shut them down.
Yes, Your Honor.
So that those variances and vagaries actually will wreak havoc to your pricing.
That's correct, Your Honor.
Okay. Now, if we construe Section 30 to refer only to an authorization on the part of PEMC to have rules on a net pool basis, it will give a lot more freedom to distribution utilities to negotiate from a position of strength vis-a-vis their power supply agreements. And from the way the phraseology of Section 30 is made, I think there is possibility or room for us to do that. You think that is feasible?
That's correct, Your Honor.
Okay. Now, in a situation where you have market power, and you definitely have market power at 60% of Luzon, that's market power, you could actually negotiate a power supply agreement which does not need to pass on the change of fuel prices of the GenCos to the customer. In other words, you can actually negotiate a contract that says any change in the fuel of this plant, which will result in price changes, will not be passed on to me, Meralco, for passing on to the customers, but will be a risk borne by the GenCos. After all, GenCos are deregulated, and the deregulated market by nature should be ready for windfall profits as well as sudden losses.
Your Honor, the different GenCos, Your Honor, are also very shrewd in their negotiating. Their negotiating teams are very shrewd, Your Honor, and we have had.
But Meralco has one of the largest law departments in the country.
But even
and
with that, Your Honor,
and it can hire a very expensive justice like Justice Feliciano and Attorney Lazatin.
Your
and
Honor,
the entire ACRA team here, including the son of Justice Natura.
we are up against the Aboitises, the San Miguel, Your Honor, the Consungi, all of these, Your Honor.
But you have been in the power game longer than all of them. Your negotiating strategy outruns all of theirs.
We hope, Your Honor.
Unless you also want to be a GenCo. Is that it? You own 100% of MGen.
Your Honor, I am not familiar with MGen, but I'm familiar with Redondo, and I think it's somewhere around 40%.
Can you find out for me if MGen is 100% owned by Meralco?
And,
it has a shareholders agreement with Therma Power to operate the Subic coal plant. Of course, that has not yet gone into production.
That is the Redondo Power.
That's the Redondo. So MGen
Power
is 100% and it has a shareholders agreement.
It's, as far as I know, Your Honor, the interest of Meralco there is about 40-some%, Your Honor. I just don't know.
Okay, well, we can do some computation later.
And it's not even starting, Your Honor.
But you see, the business model of Meralco can actually profit from the fact that you actually have a virtual monopoly. It's a virtual monopoly because of your legislative franchise. That's why the law calls your customers your captive market. The more customer base you have, the more you expand your profit base. And the law will allow you to really profit from your distribution charges. But I think that the way you have to earn your money also is at the same time to provide least cost.
The earnings of Meralco, Your Honor, are highly regulated, Your Honor.
Yeah, but it's number one,
thank you.
right, in the country. Even I would not mind being the most regulated business in the world if I'm number one also.
I hope that will continue, Your Honor. I'm not sure about the figure. Yeah.
But at the same time, what you want to project to the public is you are very interested in consumer welfare. So what I'm trying to tell you here is that with proper regulation, maybe your wish to continue to be number one will continue, as long as perhaps you don't continue to entertain conflicts of interest. Because how can you negotiate well with the GENCOs if you want to be a GENCO yourself? Unless you want to provide a different pricing preference to MGen vis-a-vis your other suppliers.
There are certain guidelines, again, Your Honor, that will be covered by the anti-competitive provisions, Your Honor, of the EPIRA Law.
So the supplies that are being given you and that you are able to buy from the market is not able to supply your 20-90%, that's why you're going into power generation?
That's my understanding, Your Honor. At least for the Redondo, Your Honor, which is a coal plant in Subic, Your Honor. But that has been stopped, Your
Okay.
Honor.
You can always walk away from negotiations with the consumees if they don't want to say that they will absorb the losses that will arise from the increase of fuel prices. For example, when you allowed in the letter that you sent to ERC in December 5, the change of fuel from gas to liquid fuel to 3 of your power plants in Batangas, you did not try to think of not passing on to the consumer the business risk arising from the fact that the gas pipeline of Malampaya would be shut off. Rather, you just set it off as, anyway, the consumers will pay. But you are under statutory duty to provide least cost. Why did it not factor in?
Your Honor, from what I understand, that's also just the fuel cost that is also being passed by Ilian and Santa Rita, Your Honor.
Yeah, but I know this is a business. GENCO is deregulated. If a deregulated market is a deregulated market, then they should be able to accept losses. If their fuel prices rise, that's their lookout. But because they have a contract with you, they have to continue supplying you. But why were you just so willing to pass it on to your customers?
It's not as easy as that, as I mentioned, Your Honor.
Why? The consumees seem to be nice people. I mean, as against your battery of lawyers, I don't think that they can really. Nobody can afford to shun Meralco. Nobody can afford actually to cross Meralco with such 70% corner of the supply of the distribution market.
Just as an aside, Your Honor.
It's not as if it is a contract of adhesion. Huh?
Your Honor, look at the coal supply, Your Honor. My understanding is that for the coal plants, Your Honor, we only have 52% of their capacity, Your Honor. And everybody knows that coal is the cheapest power supply, Your Honor.
No, actually, hydro is.
Well, hydro is unreliable, Your Honor, insofar as reliability is concerned. In fact, if you will note from our profile, Your Honor, we don't have any hydro, Your Honor.
Is it true that some of your PSAs, even of your hydro power plants, are indexed to the coal price index of Newcastle?
We don't have any hydro contracts.
You don't have any hydro contract?
No.
So
none, Your Honor.
what kind of contracts do you have that are indexed to coal price index, Newcastle coal price index?
As far as I know, Your Honor, I think, can you show the, we have a few
In
plants,
other words, what I'm trying to ask you is you have such legal muscle, market muscle. You can, of course, get a contract that will be favorable to the consumers And I believe strongly that it is the duty of ERC to ensure that your contracts are framed in that way. Otherwise, again, there is a failure of regulation. Don't you agree with me?
I agree with you, Your Honor, and I'm just asserting that Meralco believes, Your Honor, that it has been prudent in its contracting.
You have already said that you play by the book. Now, I'm going eventually into the question of the degree of diligence that the law imposes on Meralco. If you are going to be granted a monopolistic franchise, is there a greater degree of care that should be required on the part of a monopolist franchisee to ensure that the public interest is not unduly sacrificed?
I think that's precisely the rationale, Your Honor, for the regulation of the distribution utilities, Your Honor.
Correct.
As well as Transco, Your Honor.
So why were you spending time trying to defend the interests of GenCos by saying, let's not convert them into public utilities? I understood the latter part where you were saying, when you were answering Justice De Castro, and you were already saying that it is a heavily regulated economic sector industry.
No, Your Honor, it's part of the issue that was raised, Your Honor.
But I guess
so we had to cover it.
But I guess that you and I both know that there is already a very comprehensive list of to-dos on the part of both the DOE and the ERC vis-a-vis the GenCos to ensure that there is sufficient regulation.
Yes, Your Honor.
Yes. Do we already have open retail competition? Are the conditions for the regulation of the GenCos already here?
Your Honor, there is, I would say, the start, Your Honor, in the sense that consumers that have consumption of 1 megawatt peak demand per month for the last 12 months is already in place, Your Honor. And in fact, I think I mentioned that 28% of our load customers are already contestable.
Contestable markets.
Yes.
What is the threshold?
The threshold right now is 1 megawatt per peak demand, Your Honor. The next threshold, I understand, is 750 kilowatts, Your Honor. And that will probably take a few more months or years, Your Honor.
Do you agree with me that so far the questioning of the justices have raised primarily legal issues on the legal standards that are imposable in Meralco and ERC and in the DOE? While we may have had asked questions of fact, all of these questions of fact were only taken by way of context to float the legal standards.
I understand, Your Honor.
Okay. That's why I fully believe that we have jurisdiction over all these issues. But because the proportion by which we're taking the facts into consideration is not in the sense of a full-scale factual investigation, which is going to be conducted by ERC, but it is only to find out whether the regulatory mechanisms that the EPIRA requires to be set in place are actually in place. Don't you think so? That is how we have been asking our questions?
It appears to me, Your Honor, that that is the direction of Your Honor.
Okay.
But
now I'm curious with your answer in paragraph 1.61 of your contract. You were saying you contracted 90% of your power requirements to avoid volatile WESM prices. So, but your contracting of your PSAs were not because of the Malampaya shutdown, or were they already in anticipation of the shutdown?
Your Honor, the background is that upon the establishment of the WESM requirement that we can only source from bilateral contracts not more than 90%, so at least 10% was for the WESM.
Okay.
And in fact, my recollection, Your Honor, we started with about some 40, 30, high 30s, Your Honor, to start with WESM, and gradually going down up to about 16 or 15%. But once after the 5 years, Your Honor, that is on 2011, we started to reduce our purchases from the WESM, and the average purchases, I believe, Your Honor, are just about between 7 to 8%, Your Honor. And I think there have been years where it was lower than that.
Now, you actually consented to First Gas change to use expensive liquid fuel. When you allow a power plant to change the fuel use, is that not an amendment of your contract?
Yes, Your Honor.
It's an amendment of your contract.
It is an amendment.
An amendment. That's correct. That's correct.
Yes,
Technically, that's correct.
Yes.
Now, if your contract is amended, then do you not have to ask for the permission of ERC before you can amend a major term of your contract?
Your Honor,
in other words, what is ERC for? If at any time you can change the terms of the contract that you had signed with one of your PSA bilateral partner.
my understanding, Your Honor, is that the change in the fuel supply, although I'm not very familiar with the need to supply contracts, Your Honor, my understanding was that during the meetings, Your Honor, where ERC was present, Your Honor, this matter of utilizing utilizing replacement fuel for this natural gas plant so that they will run, Your Honor, during that period, because what was lost was 2,700 megawatts, Your Honor, at least with the use of alternative fuel, 1,420 was brought back into the system.
In which case, should they not have had a hearing before a major amendment took place?
Your Honor, as I said, I'm not very familiar whether the supply contract had that proviso that they can use alternate fuel with respect during certain periods of time, and whether that was approved by the ERC.
Have you found anything in the law or in the rules that allows a change in the fuel price that will result in the spiking of generation costs to be passed on to the customers? Is there anything in the law that allows the passing on of these costs to the customers?
I'm sorry, Your Honor.
If there is a change in the fuel of a GenCo plant, is there anything that allows the pass-through, this to be considered as a pass-through cost, considering that this is an amendment of the contract?
Your Honor, I was just handed a note that the replacement power is allowed in the contracts that has been approved. It has been approved by the ERC, Your Honor.
There is a standard provision on replacement power?
No, that's what I was... replacement fuel.
Replacement fuel.
Yes, Your Honor. I think it is allowed in the contract, and has been approved by the ERC.
All right. So it only requires your consent, and it does not require ERC's consent? Because the phraseology of your letter says, we have consented to the change of the gas plants to the use of liquid fuel.
Yes, Your Honor.
So it is only Meralco's consent. Meralco is the sole determinant of whether the prices of generation cost will spike or not with respect to those 3 power plants.
Well, Your Honor.
You were the sole determinant. You didn't clear it with ERC. You didn't.
It is pre-cleared.
No, you were actually telling ERC that you had consented. Now, if you say that this December 9 action is an approval, then I take it as an approval, and Justice Leonen's theory is correct.
My understanding, Your Honor, it is already in the contract that was approved by ERC. Now,
then if it's in the contract, why did you have to have consent? You had to have consent to the replacement?
It is because it will entail additional cost, Your Honor.
So in other words, only Meralco determines, it is sole potestative on the part of Meralco that the fuel composition is changed.
Your Honor, here, there was no choice, Your Honor.
Okay.
Natural gas.
Yeah, I know.
Understood.
I know. I know.
There was no choice.
Actually, that's another legal theory. But actually, what happens here is that Meralco was the sole consentor to the change in fuel.
Yes, Your Honor. It's,
Okay.
It is just a change in the fuel, Your Honor, to convert that into energy. The contract that we had with
Now,
them is
I
primarily
heard
energy.
that some electric cooperatives are able to insert in their contracts a provision that says that if there is a shutdown or there is an emergency shutdown and there is replacement power, that the cost is to be borne by the GenCos. If this is correct, how are cooperatives able to do that, and why is Meralco not able to do this? Now, I want this to be confirmed.
Your Honor, all of the contracts that we have a provision for replacement power. The issue, Your Honor, and that's what is negotiated, is if, Your Honor, when you negotiate with a power plant, they will want, one, an allowance, Your Honor, when, at the time when they will shut down, because they will have to have maintenance. And then they would also have some allowance for forced outages.
Yeah.
These machineries break down once in a while, Your Honor, so that
Yeah.
you will have
Whether
to give them
it is-
allowance.
Now, for
Now-
scheduled shutdown, let me ask. Scheduled shutdown, it can be considered as part of the negotiating parameter. It should already be part of the price formula. Can you not do
Yes.
that?
It
For
is.
scheduled shutdowns, it is?
It is, Your Honor.
Okay. Now, for forced outages, since these are forced, why do you shift the burden to consumers who cannot negotiate with the power plants, and why are you not negotiating on behalf of the consumers?
Your Honor, if it is for this, beyond these allowances, Your Honor, if they exceed, then the agreement is that the replacement power will be charged in accordance with the contract. Any excess is shouldered by the GenCo.
In accordance with the contract
Yes.
price. So
Yes.
there is no spike on the contracted price component. In other words, for the November generation costs, where you had about 73% left, which were priced at the contract prices, even if they used liquid fuel like Ilijan, etc., the ones in Batangas, the price they passed on to Meralco is at contracted price, not at the higher liquid fuel price. Are you able to make the undertaking before this court that nothing was passed on to the consumer that was already at the contracted price?
I think there's some, I have to explain, Your Honor. This is the shutdown of the plant itself, not the shutdown of another plant. If it is the plant that you are contracting has a scheduled shutdown, if it is within the scheduled shutdown or scheduled forced outage, the replacement power is provided for. And it is the GenCo that absorbs that.
Okay.
But anything beyond that, Your Honor, if they exceed the agreed allowances, then the replacement power will be paid in accordance with the bilateral agreement. The excess is shouldered by the GenCos. It is not passed on to the consumer, Your Honor.
Okay, please elucidate that further
Yes,
in your
we will
memorandum.
do so, Your Honor.
Because what we want to ensure is that Meralco, having all the contracting muscle that any company can get in this country, should not have passed on these spikes to the consumers if it could have avoided that in the contract.
These are not, Your Honor, as I said, anything beyond the agreed schedules, Your Honor. It is borne by the GenCos, Your Honor, the excess.
Okay. Now you were saying in your page 39 of your comment that you had sent letters in October to SEM Calacca and to SPPC. Now you knew already that November would be the shutdown month of Malampaya. Why that very delayed response? You had the primary duty to ensure least cost to your customers. Why the delayed movement?
Your Honor, as I understood it, these scheduled shutdowns, Your Honor, of this plant were supposed to be in October, Your Honor. But because they were requested, because of the barangay election, Your Honor, they were already moved, Your Honor. That's my understanding. So it is not as if they were there from the very beginning, Your Honor, that we knew that they were already going to overlap with.
But you have your schedules a year ahead.
That is for the Malampaya, Your Honor. And for this, Your Honor, if Malampaya is scheduled in November.
But even the shutdowns of all the plants with whom you have a PSA, you have a schedule.
Yes, Your Honor, but precisely because of the October election, they were requested to move. Some scheduled shutdowns of some plants were requested to be moved. That is Your Honor, it was the request of the COMELEC. And to ensure that there was power during the barangay election, some GENCOs moved their scheduled maintenance, Your Honor.
So we should charge it to the budget of COMELEC.
If there is statutory basis, Your Honor, maybe.
COMELEC was the one who requested for the postponement, and we should charge it to COMELEC.
That was one of the reasons, Your Honor, why there was this overlapping of scheduled maintenance, Your Honor.
Okay. The coordination meetings that you were saying took place in July up to November. What happened to your proposal again to use the administered price under the WESM?
As far as I understand, Your Honor, the response to Meralco's proposal for administered prices was that it was not within the rules.
Why not?
The rules, as I understand it, only covers natural calamities and international and national security emergencies.
And so we would rather have the very high marginal clearing price rather than the administered price.
That's what happened, Your Honor.
So it's like a case of the tail wagging the dog, where the minute rules that have been devised by the market players control the whole thing, and the statutes, very clear provisions on what the whole, what is supposed to be achieved by the power sector are basically set aside. Is that the situation that has happened here?
Well,
that rules that are so opaque, very difficult to understand for everybody, with power sector agreements that are not fully divulged to the public basically just has to accept that these are the outcome of rules. Rules that disregard Section 23 of the EPIRA. Is that the case?
It would appear that way, Your Honor. There was this suggestion, and in fact it is in a PowerPoint presentation of Meralco, and that was the response, I understand, that was given, that it was not possible within the rules to have administered prices.
Where can the court get copies of the minutes of those meetings? Can you supply us a copy of the minutes of those meetings?
I don't know
We
if we
will
have
also
copies.
direct PEMC or ERC to give us the minutes of those meetings, coordination meetings, where you were suggesting that the administered price be used. Okay? We will issue the appropriate written advisory to that effect.
I only have, Your Honor, our PowerPoint presentation during that day, and in the on the next steps provision, Your Honor, and 1, 2, 3, 4.
Please submit to us those PowerPoint presentations you made during those coordination meetings, plus the minutes if you have them, and we will issue also an order to the other parties with whom you had those meetings to give us the minutes.
We will do so, Your Honor.
Okay. Now, in which case, Mr. Counsel, again, the question is, knowing that these are the kinds of questions that we are able to ask, and the extractions of responsibility that we are willing to outline for everyone so that it is as clear as possible what everyone should do under the EPIRA. Do you not think that this court is going to, and in fact, be able to solve many of the questions that are bedeviling Meralco itself?
Your Honor, during all the discussion, Your Honor, I understand different issues were brought out, Your Honor. I'm not just very clear in my mind, Your Honor, whether all of these different issues were squarely raised by the petition, nor by our counter petition, Your Honor.
I don't think they were. But you see, in our review of the EPIRA, we have gone through not only a long-term lens in looking at the whole legal structure, we have also had to take a comprehensive view of things.
I understand, Your Honor.
The four sectors, we try to understand as much as we can, because what we wish to avoid is having a short-sighted resolution of this. We are not about to replicate the role of ERC at all, but it is clear to us that we are supposed to lay down the parameters of how the EPIRA is supposed to be played out.
I understand where is on.
Well, I'm sorry, that's my position. Justice Abad might differ and some others might differ, but some of us. Yeah. All right. Again, this is not with the proper advice from some of my colleagues here. We have not yet made a decision, but already you can see that some of the guidelines are being already ferreted out by the interpellations we have been asking you.
Yes, Your Honor.
Okay. So now I turn over the microphone to Justice Leonen. Please, Justice Leonen.
With the indulgence of my colleagues, just to summarize some of the issues which we might want you to respond also in your memoranda. But before that, I think that clearly the content of the TRO was very clear, and that there was a, shall we say, an oversight on the part of somebody who interpreted the TRO. And clearly what you passed on to as generating costs to the consumers for the December billing and the January billing, there's no February billing yet, was 5.67. And I'm correct in that, I assume. And that therefore, there has already been an automatic pass-on of 5.67. I think the legal question that you now have to tackle, and for which some leadership, I think needs to be done maybe by DOE or ERC at this point, is what do you do with the rest? Because I assume that in the December billing, it is more than 5.67, but you already did the automatic pass-on. And in the January billing, you already also did the automatic pass-on. I assume that in January, it was more than, I'm hoping that it is not more than 5.67 as a consumer, but let us just assume the worst, that it is more than 5.67. So the legal question that you now have to decide in relation to this would be whether you need to apply, because you already did the automatic pass-on to the generators with the ERC, and or there are some other alternatives. I'm only concerned that because of the, and we all commit mistakes, the mistake in the reading of the TRO, that somehow some leadership needs to be exercised by one of the parties here who is part of the power sector, I suppose the DOE secretary maybe, to cushion the impact on the customers. I hope that we will not be surprised in our, this is just an expression, that we will not be surprised in our February billing. I hope you understand that as government employees, we may have to make adjustments also, but please take that into consideration. Just one point.
Yes, Your Honor.
And I understand, again, there must have been an oversight, because very clearly the court's intention was very clear in the words of the TRO. And I will ask the PIO to actually publish the TRO in order for the entire public to actually see the content. Second, perhaps the parties can also take into consideration when answering one of the issues whether there is grave abuse of discretion on the part of the public respondents. I refer to ERC and the DOE. In immediately or within that time period, accepting the letter of Meralco and the generating costs, under the following circumstances, what you know now about some plants that did not dispatch but offered, or was, did not operate. Second, that the supply and demand outlook, according to you, looked white, except for one day when it was yellow. Yet, even if the supply and the demand, even considering the reserves, because I understand yellow stands for some problem with the security reserves, but it was white, yet the price shot up to 9. And within that condition, didn't the ERC commit grave abuse of discretion? Just a question, you don't need to answer it now. The ERC did not exercise its powers to actually take a look at that spike. And whether this can be a badge of abuse of market power or anti-competitive behavior, not that we're saying that there is, but it can be a badge, meaning to say that they can see that there is something is wrong, so that it may have been a grave abuse of discretion on the part of the ERC to act too quickly on a letter. The third condition is that it was an extraordinarily high, a high historically, a high in terms of prediction even, because I think Meralco predicted it at 7, yet it hit at 9, and so on. Next. Perhaps you can also tackle in your memoranda, also this refers to the petitioners, by the way, all these issues. Assuming that it was valid to do automatic pass-on for generating costs, we are just assuming for this issue. Of course, you have to answer the other issues. That the letter that you gave of December 5 is of the nature of not an automatic pass-on, and therefore we go back to the general rule in FDC and Nasecore. Maybe because you mentioned it, whether or not ERC committed grave abuse of discretion in examining your application of December 5 and not considering the WESM administered price, because you did mention that that was on the table with ERC. Next, issues in relation to the allegation of anti-competitive behavior. Perhaps you can tackle whether the relationship of Meralco and TMO, insofar as the nomination of the offers, is per se anti-competitive, or whether it can be rationally considered as not anti-competitive behavior in the light of Rule 4 and 5 of the ERC competition rules, in the light of the ERC, the EPIRA, and in the light of the Constitution. So that relationship where Meralco can actually, when a distribution utility can actually nominate the offered price. Next, perhaps you can also tackle that Meralco is under least cost obligations. When a generating company offers in the WESM, in the spot market, it is under no obligation of least cost. It has all the opportunity to trade the way it wants to trade. Of course, minimum hopefully to reflect the right price, variable cost, but it's a business decision. But Meralco, on the other hand, is obligated by least cost. Whether a bid of 62, considering the circumstances, and whether a bid of 62 per se is in fact violative of your obligation for meeting the least cost. Again, not to be answered now in view of the lateness of the time. Please be certain that our amicus will be, I think, covering the issue of gross pool and net pool. I think there are economic considerations behind this, and we have some of the best amicus that can tackle this, the gross and net pool. I suppose all of us know that there are some recommendations of consultants made to DOE in relation to improvements of the WESM and the PEMC. I think there was a 2009 letter by some consultant relating to the gross pool and the net pool. But in any case, the point here is, please be assured that the amicus will be tackling the economic reasons behind gross and net pool, and then the clearing, the market clearing. I understand there is some economic incentives behind it. There's some economics behind it. The market clearing and the pay as bid. But of course, the amicus will, I think, tackle also the character of our market. I mean that we are in a situation where I understand the supply has a particular structure in relation to the demand, of which we have no judgment yet because we need to hear the parties. just some points which perhaps you might want to consider in your memoranda, and of course in tackling that issue regarding the misinterpretation of our TRO. That's all, Chief.
Justice De Castro.
I just want to clarify on my end that the issues raised by Justice Leonen should be taken in the proper context. That is, we should focus on the questions of law.
Yes.
First, is there any provision of the EPIRA Law which violate the Constitution? And with respect to the problematic implementing rules and regulation and the WESM rules and the administrative issuances of ERC and the DOE, do they conform faithfully to the provisions of the EPIRA Law? Or was there any violation of the EPIRA Law? Because that is how we should consider all of this. Was the problem caused by the implementing rules and regulations and the WESM rule, which do not comply with the standards set by the EPIRA Law? I think that is how we should consider all of these details, because the court will have to focus to the legal issues, the constitutional and legal issues. That is the basis or the fundamental premise of all of these questions now being raised, and which could have been the cause of the problem which is before the court now.
We will do so, Your Honor.
So there being no further comment from any of my colleagues, at this point I'd like to announce that the session, again, this session will resume on February 11, with ERC and DOE being given 30 minutes, 15 minutes each for the ASG San Vicente and ERC Executive Director San Juan. Intervener will be given 30 minutes. The additional respondents will be given 40 minutes for their oral arguments, their presentations. All the arguers, all the parties who will be arguing, are under the same instruction that all the PowerPoint presentations and the documents to be used during the presentation must be submitted the day before the scheduled session. So with this session is hereby adjourned.